All right, Ms. Rivers, are you ready? Let's get on the record in State versus Christopher. It is about 9:15 on Tuesday, the 6th of December, runoff election day. We're starting a little late because we are waiting on a few more jurors. Bad weather today. I'm happy to report Mr. Christopher was here before 9 o'clock, which is a good development. And I thought we could use this time while we're waiting on additional jurors to cover a few of the pretrial matters that we didn't get closure on. Deputy Gordon, do they know to turn the light on? Have you educated them on that, or how are we going to know? You're just going to check from time to time? Oh, so you can see you've got those two tunnels of vision. Excellent. You're multitasking. So why don't we circle back to the motions that we had, the pretrial motions. Ms. Wood, was there anything more you wanted to discuss concerning your motion to exclude late disclosed evidence, which, if I'm remembering, fell into two buckets? There were the medical records, 700 plus pages, but the state represented they weren't planning on diving deep into that, other than, I guess, confirming the facial fracture and the ankle fracture. I know I heard Mr. Hand say yesterday something about brain damage and this and that, but anything that's new that flows from those records, I'm thinking we ought to stay away from because of when they were disclosed. But using the records and having the doctor talk about them to provide the medical experts saying, no, there was a broken ankle and there was a facial fracture and that would be painful, or anything consistent with the injuries about which everyone knew all along, I think is appropriate. And then we had Ms. Hooper. Is that the right name?
Yes, Judge.
Ms. Hooper and cell phone records, which initially struck me as particularly problematic on a Brady level. But then as I looked through the cell phone records, it seemed more like it was going to be an issue for the detective or the lead officer to try to explain why his report says one thing, but the records don't seem to support that. And that's sort of how we left it. You've had time to think about it and confer. Anything more you want to discuss concerning those two sets of discovery?
I think we're good with those, right? Mm-hmm. And Judge, I do want to just let you know we were able to locate Miss Hooper.
Well, look at that.
But we may be able to not have to call her.
Okay. And finding her is probably the more important part, because she could look at those records and say, I don't know what Romuno was saying in the report, because that's not what these records show. And then he'll just need to explain it. Okay. I'm going to leave that then on the things are okay for now, unless and until you bring it back up.
Thank you, Judge.
We have a motion from the state to introduce business records, and Mr. Hand helped me understand it's not police reports. It's all 911. I'm assuming if it's not Ms. Latner's, it's the equivalent of. She may not be the right person to get it in because it wasn't APD, it was Roswell. But the pages that were attached to the hearsay notice were 911 or CAD reports and not police reports. Is that correct, Mr. Hand?
Yes, sir. That's correct.
Okay.
Both 911 calls.
Okay. There was more than one.
Yeah. So the one made by the victim at the hit and run, and then one made by Mr. Christopher.
Okay. Got it. That we heard about yesterday.
Yeah.
And these come in through a Roswell officer, or Ms. Latner's has such extensive authority, she covers Roswell 911 too?
Judge, it was the intent of the state to just tender them and have them played. But yes, initially, while the victim is there, because he'll confirm that he did call 911. Okay. And we'll play them. He
can recognize his own voice, so he could get the 911 call in insofar as these documents that are connected with it. They'd come in because they've been authenticated. There's a records custodian, et cetera.
Yes, Judge.
Okay. Ms. Feely or Ms. Wood, any objection, assuming the proper foundation is laid, are any issues with the state's business record notice?
No, Your Honor.
Okay, so it sounds like that'll go smoothly enough. Then I think the only thing left that I'm aware of, but you all may have more, is the state's motion to prohibit improper argument regarding quantifying basically the burden of proof in this case. And Ms. Feely, I did get the chart, which I've seen before, but we can make that an exhibit if it needs to be part of the discussion. Mr. Hand, why don't you start us off and let me know if there's more you want to get in the record about your concern about what you think the closing argument will be from the defense about burden of proof.
Yes, Judge.
And let me ask you this of the defense before you get going, Mr. Hand. I'm looking at the slide. Looks like actually literally someone took a photo of the slide and sent that. But it's very, very readable, and it's the stair steps that with which I'm familiar. Is this what you, Ms. Feely, or you, Ms. Wood, would use in your closing?
It's what I used in our last trial as well. Yes.
Okay, but I'm asking about this trial, and this is what would be used, not a different one, something that's got percentages hung on it or anything like that. It's the standard stairs.
Yes.
Okay, great. That's helpful. So I'll help focus your discussion. It was a good motion, understood it. It includes a case where actually fussing at the prosecutor for totally mischaracterizing what a beyond a reasonable doubt is, doesn't even require 51%, which of course would be the civil standard, but it was all numbers. The defense slide, which I can share, so we're all looking at it. The defense slide doesn't have numbers hung on it. And what it does have is some language that, if not taken directly from case law, matches case law, how courts have defined reasonable suspicion or probable cause. Preponderance is in fact what I tell a jury in a civil trial. It's the greater weight or amount of evidence. And then I do the little scales with my hands. That's a preponderance. So this slide, as it's deployed, doesn't seem problematic, but maybe you have encountered narration accompanying the slide that gives rise to your concern.
Well, Judge, it's actually both.
Okay.
It's three things. The first is looking at this slide. The problem is that the case that I cited stated that that standard beyond reasonable doubt is not susceptible to quantification.
Mm-hmm.
Looking at this slide, in thinking about the definition of quantification, which is to measure, by listing out several levels of standards of proof that are all but one are relevant to this trial. What you're doing is you're measuring it, saying, okay, with level one, this is a very low standard. Then here's a low to medium, then here's a medium, and here's a medium to high, and here's the very top. And so by doing so, what you're saying is you're measuring the proof that's needed to be beyond a reasonable doubt. And so at the bottom, you're saying you only need a little bit of proof. And then by beyond reasonable doubt, you're saying you need a lot of proof.
But isn't that accurate? Two things. One, isn't it accurate that you actually need a lot of proof, whatever a lot might mean? And going beyond that is problematic, because then if you start saying, well, it's like 75% is a lot, that's an issue. But isn't it legally, and I think factually correct, that this is the appropriate array, that you need more evidence for each of the levels as they're ranked? They are correctly ranked. And some jury charges even say, if we go back to the civil side, if I'm instructing a jury on punitive damages, where they need to find something by clear and convincing evidence. I tell them that is more than a preponderance, that the judges are told to tell the jury that clear and convincing means more than a preponderance. And with preponderance, it's actually okay for judges to say 51-49 because it's the scales. And anything that ever perceptibly tilts the scales in one direction, that's the prevailing side in the civil case. So there is a great focus on quantification. It's if you find yourself leaning in a direction, that's the side that wins in the civil matter, unless it's clear and convincing, because that's something more than a preponderance. There's no number hung on it, and jurors get frustrated. Well, how much more? That's what jurors need to find out. But it is also legally, and I believe factually true, that reasonable doubt is more than clear and convincing. And so I don't believe it's inappropriate or burden shifting or burden blurring or anything like that. And you haven't said anything about burden shifting, misleading the jury to say reasonable doubt is more than clear and convincing. I don't know that it helps the jurors because they're going to say, what the heck is clear and convincing? But it makes an important, and I believe correct point, which is it's the highest standard of proof known to law.
And Judge, I'm not saying it's not accurate. What I'm saying is.
You don't like it.
Well, what I'm saying is seeing all of these different levels of standards of proof, most of which jurors probably have not seen, right? It's confusing. And it's also the depiction that's inaccurate. I mean, the highest level is beyond all doubt. But here in this photo, you have beyond reasonable doubt at the top. And so it just presents it as the highest form or 100% proof when it shouldn't. And I truly do believe it confuses the jurors.
Okay.
And it heightens the burden for the state, which we believe is inappropriate.
Do you think it is improper for a defense attorney to tell the jury beyond a reasonable doubt, it's the standard you would use in making the most important decisions in your life, like whether to take a loved one off life support or those types of serious decisions? Do we amputate or not? We're not sure what's going to happen. What's your reaction when I hear defense attorneys say that fairly regularly when they're trying to emphasize, I don't know, it's you got to be pretty darn sure with the decision you're making. Is that an inaccurate statement of the law, or is it problematic beyond you don't like it because it makes it sound like you've got a pretty high burden of proof, which you do?
Right. So, Judge, I would prefer we stick with the definition of actual reasonable doubt. And I mean, in the same way that jurors may still have questions about what that is, Your Honor has the ability to further clarify. But when you start to add narration about this is before you take your grandmother or relative off life support, that's going to be different. For some folks, that's going to be an exceedingly high percentage, which is why we use the terms to define it, which is, fair and impartial juror and a common sense juror that's a reasonable person. To have scintilla in front of a juror and then reasonable suspicion, probable cause, it really does heighten. It's the depiction of it, Judge. It's not necessarily just whether it's inaccurate. It's just it makes it a super high standard.
Okay. Thank you. Let me hear from the defense, if there's anything you want to add.
There's no percentages on this, which is discussed in the motion. It's not a misstatement of the law. The jury charge that the court gives says that it's not to a mathematical certainty. And I don't know how much time we want to spend on this, but the state uses gas pumps and dollar bills and all kinds of demonstratives. And what we do when we talk about the slide is not narration, it's argument, and it's proper.
Okay. I agree, as long as we're staying away from quantification. And I haven't heard either of you, Ms. Wood or Ms. Feely, quantify. I haven't heard the state do that either. That's where you get into the messy area that the prosecutor did in Debelbot, Debelbot versus state 308 Georgia 165. where that poor prosecutor really drove into a ditch on that one by actually driving the jury down the staircase improperly to below preponderance, but was hanging numbers on it. So I understand your distaste for this chart, but I don't think it is a legally inaccurate depiction of what otherwise is just words for jurors. In the same way, and I thought it was an apt analogy of that dollar bill. And who is that under there? Well, we all know it's George Washington. And you're pretty certain it's not a chart like this, but it helps illustrate what otherwise can be some dry legalese. And while I am, to your point, Mr. Hand, permitted to explain things to a certain extent, if jurors have a question once they've begun deliberating, judges ought to be pretty reluctant to say anything more than you've got the jury charge. If the question comes up, we still don't understand what reasonable doubt means. What I will say, just so you know, is you're going to need to read the charge again. I won't bring them out here and say, well, let me tell you, it's not, you got to be reasonable and it's common sense juror. All that's in the jury charge, and I might read it to them again, but what I'd probably say is you should read it again because it does explain. It's the doubt of a fair-minded juror honestly seeking the truth, and it's based on reason and the evidence. It's not some crazy doubt of like, I didn't like how that guy looked. I'm going to, I guess what I'll do is continue to prohibit improper argument, but I don't find using this slide, as long as the defense isn't trying to place numerical percentages in connection with it. I don't find that using this slide is improper argument. I think it is an accurate depiction of the increasing levels of proof that our system demands of different aspects in either the criminal or the civil setting. All right, all our jurors are here. Mr. Hand, anything else you want to bring up before we bring the jurors in?
Yes, Judge, there is.
You're moving the null pros.
No, well, unless you'll take it. Judge, early this morning, maybe 5 a.m., the state received 10 to 15 text messages, photos of text messages of communication allegedly between Ms. Kayla Newborn and the defendant in this case.
You received them from?
Attorney Wood.
Okay.
It is communication, some dated, some not, some with timestamp, some not. And it's our opinion that if they produce it, they may intend to use it. And the state would request that they not, because we don't see the relevance of it. We don't know how they intend to introduce it. And also, there's no inconsistency in those text messages with what Ms. Newborn thus far has testified.
Okay. Got it. Anything else?
I know that.
All right. I would like to get the same texts. If someone can email them to me or give me hard copies, I'm happy, whatever's easier for the defense. And I'll take a look at them and then we'll talk about them. I just assume that we get started unless those texts were going to feature prominently in the defense opening.
No, Your Honor.
Okay, then let's table that. We'll circle back to it and we'll need to get resolution before Ms. Newborn testifies. Was she going to be the first witness?
Mr. Duffy, Judge.
Great. So we'll have time and I promise we'll talk about it. But it will help me to see what we're talking about before we have that conversation. Ms. Wood, anything from the defense before we bring the jurors in?
No, Your Honor.
So before they come in, just so you know the plan, I'll bring them in, thank them for their patience, swear them in, so they'll take the oath. Then I give them 10, 15 minutes worth of basic instructions. And then I'll turn to you, Mr. Hand, to see if the state's giving an opening. And if you are, you're on. And I'll explain that the defense typically gives an opening right after it, but may not. And if the defense does give an opening, they'll do that. But then your first witness will need to be ready to go. And we'll keep pressing on. Okay. And we will have a morning break. It'll be a little bit later and we'll probably break for lunch 12:30-ish. I don't usually have hard stops such that we have to cut someone off in the middle of an answer. As we're easing towards what might be a natural break, I may say, are you at a good stopping point? Or might you be wrapping up with this witness in a few minutes? And then we'll do that wrap up. Okay. And they'll all have notepads to take notes. Let's bring them in. Oops, let me stop sharing this. Ms. Wood, I got 2 texts from you. Is it just sent it twice or?
I forgot to include Mr. Hand and Ms. Nelson on
Got
the
it.
first one. So yes,
Excellent.
same thing, Judge.
Okay. Juror 13 called this morning just to make sure she wasn't supposed to be here. I said, do your thing. I'll take any seat you want. Oop, that row's full. Sorry, front row. Our Coca-Cola executive wants the back row for next time. And sir, you are welcome to sit right there. If you'd be more comfortable, it's the less comfortable chair, but if you'd be more comfortable there, that's up to you, okay? All right. Everyone can be seated, please. Good morning, ladies and gentlemen. Thank you for being here. It was messy on the roads, so it is okay that we're starting a little bit late. I had to get my younger kid to school early, and so I was here at 7:30. Like, where's everyone? There are no cars on the road, but then the traffic thickened. So I appreciate everyone making an effort. It's crowded, it's voting day, et cetera. But here we are, ready to start the trial. I also appreciate most of you answering your phones. I told you we'd call before 6, and we had a big legal blow up that we had to work through. And I saw like, it's 5:58. We still don't know for sure. So we called as soon as we could. So I apologize if some of you thought I'm off the hook. And then at 6:05, you're kidding me. What? It was not a hoax or anything like that. We were working through this legal issue until about 6. And so it was a little later than normal, but I appreciate everyone's commitment to being here on time. We also have about 400 potential jurors coming in today. So you may have gotten here on time and couldn't get in the building because there was a long line. It will be smoother tomorrow. And that ought to make it easier to start closer to 9. So I'm going to talk to you a little bit about serving as a juror and what to expect during the course of the trial before I hand things over to the lawyers and they begin to present the evidence that you are to consider. But the very first thing I need to do to make this official is to administer the juror oath to all of you. Yesterday, you took the voir dire oath to answer truthfully all the questions. You've got a more fundamental oath here that you're going to try this case fairly and according to the law. So even though you just sat down in those comfy swivel chairs, if you wouldn't mind standing up and raising your right hand. Do you swear or affirm that you shall fairly try this case between the state of Georgia and Landon Christopher, who is charged with hit and run and false report of a crime, and give a true verdict according to the evidence? Please say yes if you so swear or affirm.
Yes.
Does anyone not so swear or affirm? All right. Thank you. So a few housekeeping matters before I give you some legal instructions. You've met the jury room now. That is your home away from home. There's a refrigerator in there that has bottled water. That is for you. You can bring the bottled water out here. Please don't bring anything that is not clear out here to drink. So if you're drinking coffee, drink it back there. But if it's Orange Crush or Fanta or Coke or something, don't bring that out here, because if it spills, it shows. But the water is for you. The fridge is for you. If you bring something that you want to keep cold, you're welcome to do that. Were the snacks put out yet, or does that come later? This is a new thing. Our court administrator added to our every judge's budget is snack budget. And so those snacks are for you too. That's not my stash of snacks. So eat them, and they're more where that came from. And that's not meant to be your dietary supplement for the day, but just trying to make this as comfortable as we can make it. The two restrooms back there, those are also for you. Coffee maker is for you. If you run out of those little cup things, let us know and we'll put more there. And if you've got your preferred one, bring your own K-cup and have at it. And I think there's a microwave if you want to heat something up. We will break at least 3 times a day. There'll be a morning break of 10-ish minutes, a lunch break of about an hour, and then an afternoon break. We'll also break anytime one of you needs a break, to use the restroom or just move around or whatnot. And it is incumbent upon you to tell me or Deputy Gordon when you need that break. But there'll be that minimum of 3 breaks a day. And I'll mention this in a minute when I get into my legal charge, but there also may be some unscheduled breaks because something comes up legally and we need to shoo you out of the courtroom so that we can talk about what's going on. From now on, when you show up for court, do what you did today. Don't come in through the courtroom, but come in through the back, and you'll go to the jury room where we will keep all of you till we've got all 14 of you. We can't do anything in here in court without all of you. Everyone got here at around the same time today. It needs to keep working that way. If 13 of you are here by 8:55 tomorrow, and one of you shows up at 10, I expect the 13 of you to do a pretty serious verbal beatdown of that one person, but we can't start because one person shows up an hour late. We got to wait till you are all here. Deputy Gordon is in a good position to answer questions about where do we go to lunch? How do I find this? Is there a vending machine? You might, as you are walking around in the building, bump into any of the folks seated at these tables. They are going to treat you like you've got the plague and step back, not because there's anything wrong with you or them, but the lawyers and Mr. Christopher are not to interact with you outside the courtroom. Even something as innocuous as, hey, what's a good place to eat? If one of the lawyers from one side sees you chatting with a lawyer from the other side, they're going, wait a minute, what's that lawyer saying to them about the case? So don't, if you bump into one of the lawyers, ask a question about anything. If they are sharing something with you, it needs to happen here in court so the other side can hear it. And if we need to have a discussion about it, we do that. Do you all have the number for Chambers now? If not, I'll make sure it's put up on that whiteboard. That's the number you should call if at any time you're going home and there's an issue, you're trying to get back here for court in the morning and you're running late. As long as you let us know you are making it here, then we can be calm. It's when we can't track you down and you're not here that we start to worry, and then the deputies have to go to your home address and try to find you. So please keep us posted if you've run into an obstacle that will prevent you from getting here. Finally, about masks. I ask the lawyers and the witnesses and myself, because I could be talking at any moment if there's an objection, to not have masks while they're talking. When you have your next break, you should talk amongst yourselves about whether you want to wear masks. They are not required while you're in the courtroom. You need to wear them when you're circulating in the building, but when you're in AD and in the jury room, that is a jury decision. I just ask that you do it as consensually as possible. And so if one of your numbers says, you know what, there's a reason why I need to wear a mask and I'd like you all to, hopefully you can respect that. But we've reached a point where in many settings, even when folks are really up close, like a movie theater or the SEC championship game, people aren't wearing masks. So while we're here, you decide what you want to do with that. Note taking. You all have notepads and you are all welcome to take notes if you want to take notes. This is not a lecture. You don't have to take notes. There won't be a test at the end, other than the fact that at the end of the presentation of all the evidence, you will be deciding what happened in this case. Was there a hit and run? Was Mr. Christopher involved in the hit and run? And you will be relying on your collective recollection of what all the witnesses said. There is no video playback. If you're back there in the jury room, like, oh, what did that officer say? And you send me a note saying, could we have a transcript of the officer's testimony? My polite response will be, no, you have to rely on your recollection. I share that with you so you can gauge how much you're going to take notes, how frequently, how often. You're welcome to try to write down as much as possible, but don't let that distract you from observing what's going on. You will be determining the credibility or believability of witnesses. And it may be in this trial that one witness says, this is how it went down. And another witness said, that's crazy. It went down a different way. And you have to reconcile that. And one way you may do that is by looking at how that witness testified. Why did that witness suddenly turn away from us and not make eye contact anymore, or start sweating? Or when asked questions by one side, made eye contact and was smiling. And the moment the other side asked questions, crossed arms and leaned back in the chair. And that may be a cue to one or more of you that there's a reason to question credibility. But you'll miss all that if the whole time you're trying to write down every single word of what every witness. You can't get it all. She can, but you guys aren't trained to do that, and you don't have a fancy machine like Ms. Rivers has. So feel free to take notes. You're not required to. Your notes are private until you begin your deliberations. It's fine to share your notes with each other once you're deliberating. Well, you know what I wrote down was X, or here's a picture I drew of the guy. When the trial is all over, we will shred your notes. They will not end up on a website somewhere. So they're private until you deliberate. Then you can share them. Then they get shredded. And if we are only able to provide pencils, tight budget, although now snacks, but you're free to take notes with whatever writing implement you can manage to get in past security. All right. Before we begin the evidentiary part of the trial, I need to talk to you a little bit about several fundamental principles of criminal law, talk to you a bit about your role, my role, and the lawyer's role, and just give you an overall sense of how the trial is going to flow, not the evidence that's coming in, but structurally how it's going to flow. I'm going to start with this. This is the indictment. This is what brought us all together. It's the charging document. The defendant is charged in this indictment with 2 crimes. Crimes are violations of the law of Georgia. You'll have this indictment during your deliberation, so don't try to write down the legalese of the 2 charges I'm going to read, but I'm going to read to you right now what the charges are. Count 1 charges Mr. Christopher with the offense of hit and run resulting in serious injury or death. And the allegation is that the accused, Mr. Christopher, here in Fulton County on December 12th, 2020, while operating a motor vehicle involved in an accident, which was the proximate cause of serious injury to Matthew Duffy, that's our alleged victim. Then those serious injuries were allegedly a broken ankle and a facial fracture. That Mr. Christopher did knowingly fail to stop his motor vehicle at the scene of the accident and did knowingly fail to return to the scene and remain at the scene until fulfilling the requirements of a statute. The second allegation is that Mr. Christopher here in Fulton County on December 12th, 2020, did willfully, and this is the crime of false report of a crime. And the allegation is that Mr. Christopher did willfully and knowingly give or cause a false report of a crime to be given to a law enforcement officer. Specifically, Mr. Christopher allegedly gave a false report to law enforcement officers regarding the involvement of his vehicle in a hit and run accident described in count 1, that accident having caused injury to Matthew Duffy. So hit and run and false report of the crime. Those are the allegations. These charges are proof of nothing. They are a procedural vehicle, no pun intended, that brings us together. You should not consider these as evidence or even an implication of guilt of any crime whatsoever. Mr. Christopher sits before you with a presumption of innocence in his favor, and that presumption stays with him unless and until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or both of these crimes. And a defendant should never be convicted of any crime until each element of the crime, and I'll be telling you what those elements are at the end of the trial. Here's what the state has to prove, 1, 2, 3, 4, until each element is proven beyond a reasonable doubt. This burden of proof beyond a reasonable doubt, stays with the state throughout the trial. There's not a point where I say, all right, we've heard enough from the state. Now Mr. Christopher's team needs to put something up to try to push it back in the other direction. The defendant has no burden to produce anything, call a witness, testify himself, do anything at all. But this doesn't mean that the state has to convince you of the defendant's guilt beyond all doubt or to some mathematical certainty. The burden is simply proof beyond a reasonable doubt. And that term, reasonable doubt, means just what it says. It's a doubt that's based upon your common sense and reason. It's not a vague, arbitrary, or speculative doubt. It's a doubt for which a reason can be given. It's a reason that arises from your consideration of the evidence or lack of evidence. And as I mentioned, Mr. Christopher, the defendant, has no burden and it never shifts to him. Now, if after you've heard all the evidence in this case, you find that your mind is unsettled or wavering or unsatisfied, that is a doubt of the law and you must acquit. But if you find no reasonable doubt exists as to the defendant's guilt, you would be authorized to convict. The trial flows much like this. In a minute, I'll be quiet, and both sides will be given a chance to give what we call opening statements. This is a preview of what the lawyers think the evidence will be. It is not evidence. In fact, nothing the lawyers say in this trial is evidence. Evidence is going to come to you in two forms. The primary form will be what a witness says after she's sworn in. Come in, take an oath, tell the truth. And once that witness starts answering questions, you're receiving evidence. That is evidence. The other form of evidence will be exhibits. Maybe there's a picture or a document, something like that. So there'll be physical evidence and testimony. Nothing the lawyers say, not their questions, not their arguments, is evidence. So the lawyers will get up first. They'll give these opening statements, their preview of what you may hear. And then the state begins to present its case. The state goes first because it has the burden of proof. And when that first witness answers the first question, you've begun to receive evidence. At some point, I'll ask Mr. Hand to call his next witness, and he'll say, Judge, at this time, the state rests. They will have presented their case in chief. That's the proof they contend is sufficient to convince you beyond a reasonable doubt that the defendant committed one or both crimes. After that, we'll need to take a break because there are a bunch of legal things that we deal with after the state rests. But then you'll be brought back in, and I'll turn to Ms. Wood, and I'll say, Ms. Wood, call your first witness. And Ms. Wood may well say, I call so-and-so. But she also might say, Judge, the defense rests because the defense does not have a burden. They don't have to put on any evidence. They're free to. They have an absolute right to call witnesses and cross-examine witnesses, et cetera, but they don't have an obligation to do that. Maybe they'll put up witnesses, maybe they won't. But at some point, both sides will rest. Then the lawyers get a chance to argue to you what they think the evidence has proven. It's called closing arguments. And they're going to try to persuade you. You heard this person say this, and her testimony was corroborated by this, and it all adds up. Guilty beyond a reasonable doubt. That's the state. And the defense will be highlighting where there's a lack of proof or conflict in the evidence. And they'll be trying to persuade you that the state has not met its burden and that you ought to acquit. And it's perfectly appropriate for these lawyers to try to sway you one way or the other. But remember, what they tell you is not evidence. If a lawyer stands in front of you and says, remember, that witness said that the driver had a blue shirt, and you've got in your notes and in your mind that the witness said it was a red shirt, the lawyer's got it wrong. What the lawyer says isn't evidence. It's what the witnesses say. When the lawyers are done with their closing arguments, I will give you a more formal set of legal instructions. I'll give you the elements of hit and run, the elements of false report of a crime, talk a little bit more about burdens and this and that. And then you go back to the jury room for one last time and you'll begin your deliberations. That's going to be the first time as a group that you ought to talk about what the evidence has shown. You're going to be back in that jury room when we take breaks. You're going to have lunch. When you are having those breaks, before both sides have rested, before closing arguments, and before I've given you the charge, don't talk about the case because you don't have all the information. You'll have heard two witnesses and you'll think, gosh, the state has an amazing case. This person said this is exactly what happened. Wow, that must be it. And the defense decides we're going to call a witness. And then there's doubt all of a sudden. So you can be processing it here, but don't process it in small groups or the large group until all the evidence is in and I've given you that charge. During trial, lawyers have a right to object to evidence that they think the admission of which would be improper. This is what you see on TV. Lawyer stands up, objection, hearsay. These lawyers may or may not stand up, but they'll say objection and they'll tell me what the objection is. And I'll need to rule on it. If I sustain an objection, that just means, whoop, put the brakes on. Wherever you were trying to go, lawyer who asked the question, you need to go in a different direction. If I overrule the objection, it means that the lawyer who had asked the question can keep on going. You need to consider only the testimony that I allow in when there is an objection. So every once in a while, there'll be an objection, I'll sustain it, and the lawyer who made the objection will say, move to strike. And I may tell you, you just heard a witness talk about what she heard someone else say. So the witness says, well, that's when the driver of the car told me that he was speeding. And there's an objection, hearsay, move to strike. If I tell you, you need to disregard what that witness just said, the driver told her, I mean it. I don't say it for fun. So if you wrote it down, cross it out. And if you're back there deliberating at the end of the trial and someone in your group says, hey, remember that guy who said the driver talked to him? And one of you remembers, we're supposed to disregard that. I need you to police it. Now, the good news is, if it is something fundamental to your deliberations that pops out, we'll probably have what's called a mistrial because you will have heard something that you shouldn't have heard that is really outcome determinative. That is fortunately a rare event. Typically, it's something that is hearsay, you shouldn't have heard. I tell you to disregard it, and everyone forgets about it. It was improper for that witness to head in that direction with her answer. The other thing lawyers may do when they stand up in the middle of someone else's questioning is say, I've got a motion. And when you hear the M word, you should translate it as we've got a break, because typically motions require a more free-flowing discussion about what the lawyer's concern is. Judge, I think this witness is about to talk about, they need to tell me what that is, and they don't want you to hear it. So if there's a motion that I need to hear right then and there, you get an extra break. What I typically ask the lawyers to do, is there a way we could table this until the next break for the jurors so we minimize the interruptions? But it's perfectly appropriate to make a motion. And if a motion is made, we may need to give you an extra break. When I rule on these objections and these motions, if you're in the courtroom when I rule, you should not interpret anything I say as me demonstrating some leaning in one direction or the other. I think the state's got a good case or the defense has a good case. My rulings are simply rulings on the law that applies to that objection or that motion. It's not a finding that that's good evidence or bad evidence. It's a finding that the rules of evidence allow you or forbid you from doing that. Nothing that I say during the course of this trial should be interpreted by you as a comment on the evidence, an indication of which way I'm leaning in this case, or anything along those lines. My goal here is to make sure that the case is fairly tried according to Georgia's laws and the two constitutions. You all have an important role too. You are the fact finders. You decide, was there a hit and run? and who was involved and anything else that is necessary to be found if these charges are going to be proven. In doing this, you will be determining the credibility or believability of the witnesses who appear before you. As you're thinking about credibility, you are free to assess the physical reactions of the witnesses as they testify, the facts and circumstance of the case, the interest or lack of interest that the witness has in the outcome. What stake does that witness have as to how this plays out? A witness's possible bias for or against the state or the defense, and the means and opportunity that the witness has for knowing the things that she's testifying about. You may from time to time have questions about what a witness said or a question about a question the attorney's asked. The way we help you get those questions answered are those note cards. And we're going to need to get more out here because that's a small stack. But you are invited to jot down your questions on those 3x5 note cards. Please write only on one side of the note cards. Don't sign them. We don't need to know which juror wrote down what question. But at the end of every witness's testimony, I'll ask you all to hand your note cards to Deputy Gordon. He'll give them to me. I will review them. I will share them with the lawyers because they need a chance to object. Your questions are just as possible to be objectionable as a lawyer's question. In any legally proper question that you all have jotted down, I will pose to the witness. So it may be that the lawyers are asking a witness about what was going on and they don't think to ask, well, what was the lighting like? And you think it's kind of important to know, how well could you see? Because it's 4 a.m. What was the lighting like? So your question might be, what was the lighting like? If I find that that is a legally appropriate question, which it would be, then once we've reviewed the questions, I'll ask that witness. You don't stand up and say, well, I've got a question. It's all anonymous. I'll ask that witness, what was the lighting like? And the witness will tell you there were 6 giant halogen lamps above the situation, or I could barely see my hand in front of my face, whatever the answer is. That's how you get your questions answered. What you need to never, ever do is go online and research. If that comes to light, it's probably a mistrial and we have to start all over again. And when I figure out who it was who did the online research, he or she will probably get to watch the second trial from out there because we have to do everything we did yesterday all over again. If you've got a question, put it on a note card. Don't Google it. That is inappropriate, and it's inappropriate for the real fundamental reason that whatever evidence you receive needs to come here in court so that the lawyers have a chance to object, to know what it is you're hearing, etc. This is Miss Hansberry. Hi, Miss Hansberry. She heard me say we need more note cards, and look at that. Thank you. So now you have more note cards. So please don't conduct any outside research. You need to ask your questions here in court. It is very important that throughout the trial you pay close attention to what's happening. If at any time you cannot hear a witness or you can't see something that's on the screen, wave the arms, do something so that we can get someone to speak up, use the microphone more, switch the monitors around. Again, because there's not really a replay button here. If you say, I didn't hear that answer, I'll have the witness answer the question again. But if you go back to your deliberations and say, well, we just don't remember what happened, or we couldn't hear what happened, we are not able to repeat an entire witness because you weren't able to hear that witness. So again, we'll have regular breaks, but if you need higher volume, lower temperature, water break, whatever it is, please let us know and we'll do our best to accommodate. It's also important that you view this evidence with an open mind and resist that temptation that I've already alluded to of starting to group discuss the case before you've heard everything. It's okay to talk about like the judge's thigh is pretty hideous. That's fine. But for you all to say, I didn't think that witness was very credible, too soon. Wait till you've heard everything. And then you're in a position to juxtapose witness A with witness B, state's proof with anything the defense may have elected to introduce if they choose to do that. I'm almost done. It's important that you try to maintain something of a bubble around you while you are a juror in this case. When you go home tonight, resist any urge you might have to unload on a significant other or get online and chat with friends about what's going on here, because very well-meaning individuals may say, well, let me tell you about the time I was a juror. And I bet it's a fascinating story, but it's not this case. And they're going to tell you, hey, when the judge does this, this is what really means. Oh, if a state doesn't do this, that means there's a problem with their case. Maybe, but not this case. So what you need to limit yourself to is telling folks that you have the privilege of serving as a juror. If you need to tell them it's a criminal case, you can, but I'd avoid that. Just look, I'm a juror on a trial. When the case is over, you can tell everyone anything you want about this. There's nothing confidential about the proceedings. They're public. People can walk into the courtroom and watch. What we need to do is make sure that folks aren't sharing with you their thoughts and impressions about their prior experience or what you ought to do in a case like this. I can't stand people who do X. I think you need to do this. They're entitled to that opinion, but we need you to stay away from that opinion until you're done with your service. Ladies and gentlemen, that concludes my instructions, and we are ready to start with opening statements. Mr. Hand, are you ready?
I am, Judge.
Great. Come on up, please.
Sharing my screen.
All right. Does that big monitor say State versus Christopher on it?
Yes, yeah.
Okay, let me add one more thing while you're getting ready. I forgot to add. You all are going to discuss in your first break about masks. These seats are not assigned, other than, is it Trice? Other than Mr. Trice, who needs an end seat because of his cast. I'm not directing you, but I'm strongly encouraging you to not sit in the same seat every time. You get a different view of what's going on if you're way down at one end versus another end. You're going to see some witnesses see into their ear. You're going to see different things. So if there's a reason why you need to be in a spot, enforce that. But otherwise, please mix it up, front row, back row, left and right, so that you get an opportunity to see things from different places. That monitor is at a funky angle. Deputy Gordon, do you mind using your deputy strength to move that? Because it's sort of going straight out. We hadn't had a trial in a few days, but I think I know it can't hit the witness chair, but if we can angle it a little bit. And then is there anything on this monitor? No? All right, I don't know how to make that one work. I wonder if it's on. Is it even on? Use your reach. Is it too high for you?
No.
I don't want to call IT if the issue is we didn't even turn it on, because then we look really silly. What does it show? Even worse, you can tear it off now. All right, we'll figure out how to, ideally, that'll show what that shows. It just helps a little bit for folks who are further back in the jury box. I'm reaching out to IT to, is it changing?
HDMI.
HDMI 1.
Oh, okay, but it's me. That's back when my beard was brown. All right, Mr. Hand, I apologize. I didn't mean to leave you twisting in the wind there, but now you really should have your thoughts organized.
Yes, absolutely. May I proceed, Judge?
Please, before I come up with something else to say.
May it please the court, the members of the jury, opposing counsel. Again, my name is Pierce Hand. I'm an assistant district attorney here in Fulton County. I represent the state in today's matter. And today's matter is about a hit and run, and it's about subsequent lies that cover up that hit and run. You'll learn that on December 12th, 2020, about 2 years ago, Matthew Aaron Duffy, the victim in this case, was just getting off work. He left work about 3:30 in the morning. You'll learn that he is a line cook at a restaurant called North River Tavern. This tavern is in Roswell, and they close about 2 a.m. But because he's a line cook, it took him about an hour and a half to close down the kitchen and leave that location. Now, normally, Mr. Duffy would catch a ride with one of his colleagues home, because he doesn't own a car. However, this evening, no one could give him a ride. And so he thought, you know what, I only live an hour up this one road, Old Dogwood Road. So I'll take that trip, I'll walk home, and I'll get home to my girlfriend who I'm in a committed relationship with, and our 2 kids. That was his thought process leaving North River Tavern at 3:30 a.m. And he made it about halfway, about 30, it's an hour walk, about 30 minutes into the walk, something happened that would change his evening. A vehicle driving behind him veered off the road into the grassy side of the road and plowed him from behind. The force was so much that he went flying through the air. He then fell and lost consciousness. The impact was so great that he's not sure how long he was unconscious. What he is sure about is that he woke up and he was alone. He woke up and the glasses that he was wearing were gone. He couldn't see. He woke up and he was by himself with no one there rendering aid. The driver of that vehicle, the defendant, should have stopped. The driver of that vehicle had a legal duty to render aid. The driver of that vehicle should have been there, called in the police, but he was not. That car continued on down the road. Now, luckily, Mr. Duffy was able to reach for his cell phone. He called 911 and told him where he was. It took him a minute because he had to collect himself, but it was a very traumatic experience for him. And you'll hear that 911 call today. And you'll hear how traumatic it was for him. That road was dark. There were some lights on that road, but he ended up waking up in the dark on the side of the road, not sure if another car would come by and injure him. So that's the crash. Now comes the cover-up part. You'll hear that the very next day, December 13th at 9 p.m., the defendant, Mr. Christopher, makes a phone call to 911. And he tells Roswell Police, same police department that responded to Mr. Duffy the day before, that his car was left in a parking lot across the street from a church. He was gone all day. He left about 10 a.m. that morning. He got back to that location, that parking lot, about 9 p.m. And he'll say that he doesn't know what happened to his car, that there were just pieces missing and it must have been hit in that parking lot, that someone must have sideswiped him, and that's what happened. What he wasn't aware of is that the Roswell officers who responded the day before to the hit and run found 2 important pieces of evidence at that hit and run scene. They found a mirror with a serial number on it that traced back to a make and model of a Toyota Highlander. And they found a bumper that fell off of whatever vehicle hit him. That bumper was tan or goldish. And it was sitting right in the vicinity where Mr. Duffy was hit. So the next day, while he's talking to the police, you'll hear him tell them he's not sure what happened. You'll hear the police say, "We have pieces of this car in evidence. So what happened?" You'll hear them say, if this incident happened here in this parking lot, why isn't there debris? If this incident happened in this parking lot, why do we have a bumper that's similar to the color and texture of your bumper? At that time, they only had the car pieces, so they seized the car to further investigate. But they released Mr. Christopher, and they also released someone who was accompanying him, Ms. Kayla Newborn. So Ms. Newborn will tell you that she told police that evening, because she was also there when Mr. Landon called the police, saying that his car was damaged. She'll tell you that she was the one who picked him up that morning. She corroborated his story. She said that they arranged to meet in that parking lot around 10 a.m. She picked him up. They were together all day. She brought him back about 9 p.m. And only then did they notice the damage to the car. So here comes the confession piece. I forgot to mention that there is a confession. Ms. Newborn recently got a call from the district attorney's office about this case. She decided to come forward with this having been 2 years ago and explain what really happened that night. You'll hear her take the stand and she'll tell you that she was in the car December 12th, not the 13th, but the 12th, when Mr. Duffy was hit by a vehicle. She'll tell you she was the passenger and Mr. Christopher was the driver. She'll tell you they hit something. They didn't know what it was, but they went to see, thinking possibly it was a deer or something. And then Mr. Christopher, who was ahead of her up the road as they were looking for actually the mirror to the car, suddenly came running back. He told her to get in the car. She didn't know why, but they got in the car and drove off. She'll tell you that he mentioned to her that he saw someone laying down. That's why they drove off. Now, Ms. Newborn isn't perfect. She will tell you that she's done drugs before. She'll tell you she was drinking that night. She'll tell you that still she wanted to tell the truth. And so you may be thinking, how is her testimony going to explain her change in position? She'll also tell you that she thought after she lied to police, telling them that they were together all day, that it was over. And Mr. Christopher called her and told her he had turned himself in, it was over. Until she got a call from us. So, while no one's perfect, there's always an opportunity to come forward and tell the truth. And that's what she did. This case is about a hit and run and also a false report of a crime. Those are the two charges today. For a hit and run, the state has the burden to prove beyond a reasonable doubt that a person, a driver of a vehicle, is involved in an accident. And that person has knowledge that someone is injured by that vehicle. At that point, there are several duties that that driver has. One of them includes rendering assistance if someone is unconscious, like Mr. Duffy was. For a false report of a crime, someone has to knowingly and willingly falsely report a crime. And that's exactly what happened in that parking lot on December 13th, when Mr. Christopher called police saying that his car must have been conveniently struck by someone parking next to him or in that lot at all. That's the state's burden. And we accept that burden because we believe that the testimony you will hear today will prove beyond a reasonable doubt that that Mr. Christopher committed both those charges. So I wanted to talk about some of the testimony you'll hear. You'll hear first from Mr. Duffy, the victim in this case, and he'll tell you about himself. He'll tell you the road that he took to get home. And he'll tell you how he became injured that day. You'll also hear about the impact on his life that this event has caused. The second witness you'll hear from will be Officer Omar Brake. Officer Brake is with the Roswell Police Department. He responded that night to the hit and run. You'll be able to see his body camera footage and see what happened when he responded to the incident location. You also hear from Officer Lewis and Officer Bath. Those are two officers who responded to Mr. Christopher's 911 call to the church parking lot where he stated his car must have been sideswiped. Those two officers immediately noticed that vehicle because they were on the lookout for that particular make and model of the vehicle. You'll hear them talk about their conversation with him and how he denied that car ever being in a hit and run. You'll also hear from Detective Romano. Detective Romano will tell you that he was assigned to this case and reviewed all of the evidence from the first incident where Mr. Duffy called 911 to the second incident where Mr. Christopher called 911. And he'll tell you based on all of the evidence that he gathered that there was enough for him to secure warrants in this case. But you'll also hear from another witness. That witness will be Detective Kowalski. Detective Kowalski will tell you that he matched that bumper piece that was found on the road to that Toyota Highlander that was parked in the church parking lot by Mr. Christopher. They believe that based on all of the evidence today, that you will be able to find guilty, and we'll ask in closing that you find Mr. Christopher guilty on both counts, of hit and run as well as false report for crime. Thank you.
Thank you, Mr. Hand. Ms. Wood?
Yes, Judge.
Good morning, ladies and gentlemen. Thank you so much for being here again today. My name is Lacey Wood. I'm the attorney for Mr. Landon Christopher, and I, along with my co-counsel, Woody Feely, are honored to represent him today and throughout this week in this trial. We have a very simple request for you all. We ask that you listen. Like the judge said, listen. Pay close attention to what you hear. Listen to who is on the stand. Think about what they are saying and think about why they are saying it. And after you've listened to all the witnesses, at the close of testimony, after you've seen the evidence or lack thereof, and the case is in your hands, we ask that you find Landon Christopher not guilty. Thank you.
Thank you, Ms. Wood. Mr. Hand, call your first witness, please.
Will do, Judge. The state calls Mr. Matthew Duffy, Judge. PowerPoint somewhat broke down on me.
It was a good cover page.
That testimony will be the truth, the whole truth, that's what truth not. I didn't put it on there. State your name for the record.
Matthew Duffy.
Mr. Duffy, if you're comfortable with it, it will help everyone hear you better if you have your mask off while you testify. It's your call, but it helps us.
Yeah, that's fine. I think that.
Thank you, sir.
Thank you, Judge. Mr. Duffy, how are you doing today?
Doing all right.
Thank you for being here. Would you tell the court, where you're from and just a bit about yourself?
I'm originally from Savannah, Georgia. I've been here in the Atlanta area for about 5 years now. I've been pretty much been cooking since I was old enough to work. That's all I've done here. It's not the best paying job, but keeps bread on the table.
When you say cooking, what type of cooking? do you do?
Just general line cook, sports bars, cafes. Kind of work. The restaurant I'm working at now is a little fancier than what I'm normally used to, but it's a challenge, but it's good.
So you're no longer at North River Tavern?
No,
And do you have?
Where are you working now?
Brookwood Grill, right off of Holcomb Bridge. I can't remember the exact address, but it's right by Holcomb Bridge and 400.
Is it too far? Is it in the same area as North River Tavern or? Okay.
Yeah, it's maybe about a mile and a half, 2 miles away.
And do you tell me about your family? Do you have any kids or? you have a
I
dog?
have one son of my own, and I take care of my girlfriend's 2 boys as well. And my son lives with his mother, and I was actually supposed to go see him for the holidays right before the incident, and yeah, it's just been kind of rough adjusting, because occasionally how the weather is right now, my ankle starts swelling up and stuff, and I feel like recently my teeth have started messing up anytime it gets really, really cold.
Are those relate to injuries based on this incident? Okay.
Yeah, yeah.
And let me back you up. We will get there. Your son, how old are your kids?
4, 6, and 9.
Okay.
Mine is the oldest. The other, my girlfriend's 2 are 4 and 6, and yeah, they
Were you taking care of them at the time in December 2020?
yes, sir.
And was that just financially? Was that also taking care of them at home as far as homemaking as well?
Yeah, all of the above.
Okay. You cook for them as well, I see.
Yep. Steady asking me to bring French fries from work, and then they didn't. I do, and they're just like, "Nah, we wanted waffles."
That's good. They changed their mind.
Yeah, yeah.
I do want to talk about December 2020, December 12th specifically. Were you employed at that time?
Yeah, at the time I was working at North River Tavern. As far as I know, in the area, they're one of the bars that stays open the latest. Like, they don't close till 2 a.m. On a slow night. The kitchen might get lucky. They might let us close at 1:45 to start cleaning up and stuff. So typically I wasn't, on my way home till about 4 a.m., 4:30, almost 5 some nights.
Oh, wow. Okay. So, and what time does your workday start?
It would start at either 5 or 6
PM?
Mm-hmm.
Okay. So on December 12th, did you go to work that day?
Yes, sir.
Okay. And do you know what time your shift started?
6 p.m., I believe.
Okay. And what time did your shift end that evening?
Roughly like minutes before 4 a.m.
Okay.
Because I feel like I was already on my way home, like shortly after 4.
Okay. So what time did the restaurant close that day?
2 a.m.
Okay. And so did you stay longer to close down the restaurant or kitchen portion?
No, sometimes I didn't stay any longer than I needed to. Like, sometimes after closing, some of the employees would hang out, have a drink, play some pool and stuff. But I was gonna be off for the next 2 days, so I was just trying to get home. You know, everybody else
what
was trying to
happened-
hang out. Sorry.
Sorry, what happens for the 2 hours between, you said it closes at 2, but you were leaving at 4. What's going on in those 2 hours for you?
After we clean the kitchen, we have to wait on front of house to gather up their trash, and then the kitchen people take all the trash, and then we can all clock out.
Okay.
It's not the best system in the world, if you ask me, but hey, I just work there. You know, but yeah, normally my coworkers would hang out for a bit, and I was just trying to get home, and all of them were hanging out. So I was like, it's cool. I'm gonna just walk. You know,
And so how far did you get in your walk?
about halfway.
Let me back up. Where are you walking to?
The Studio 6 on Holcomb Bridge,
Okay.
the 400.
And how far is that from your job?
Or from a job at the time, I want to say a little over a mile, like maybe a mile and a half.
Okay.
I know it would take me about an hour to walk there, you know, on my way to work. Obviously, after working, you know, an 8-hour shift or so, I'm gonna be walking a little slower. So on the way home, take maybe an hour and 20 minutes
Okay.
normally.
And so you before the incident occurred that night, how far did you get? Do you know?
A little about halfway. Is there I walked down I would turn down Winding River and walk down that road until it turned to Dogwood. And from Dogwood, it kind of like curves around and looks over 400. So I've made it just like maybe like 10, 20 paces around the curve or so. And
Would looking at a map of that location help you show the jurors where you were in your walk before this incident occurred?
probably, yeah.
Okay. Your Honor, may I approach?
You may. So we're clear, both sets of lawyers have continuing authority to approach witnesses unless you hear me say otherwise.
Thank you, Judge.
Mhm.
Thank you.
Judge, the state is approaching with a document that's marked as S1.
All right.
Mr. Duffy, does this look familiar to you? Well, first of all, what is this?
This
Let's
is,
start with that, if it looks familiar with you, to you.
yeah, this is kind of the border between Roswell and Sandy Springs. All right, so right there's the Studio 6.
And so what is it that you're actually holding?
A map of the Sandy Springs area. Okay, there's North River Tavern. All right, so
Does it appear to be an accurate picture, a map of the area?
yeah, this is the exact route I would normally take walking home.
Okay. Does anything appear to be altered in any type of way or different from what you would normally see on your pathway home? Okay.
Is that a no?
No, sir.
Okay.
Judge, the state would move to enter the map into evidence at States 1.
Any objection to States 1?
No objection.
States 1 is admitted.
And Judge, I actually have a demonstrative of that so the jury can also see it.
Okay.
I intended to put it up here, but because of the difficulties earlier.
Tell me what maybe you don't know, and that's why there are difficulties, that you should be able to share images. You're welcome to put up a big one. It's generally easier if you've digitized things.
It just froze for a moment for me.
Okay.
So,
Well, maybe your trial partner can try to be the tech person while you are managing the witness.
Here we go. Can you see that on the screen? You might have to press the got it.
Let me do. There you go.
Sorry.
You didn't do anything wrong. It defaults to unmute and makes that special sound. Thank you.
Okay, so you were saying this is the path that you would normally follow. Where's the starting point?
Down here where it says North River Tavern.
Okay. And is that where you would normally end the red dot?
Yes, sir.
Okay. And so where were you along that path before the incident occurred?
I don't know if y'all can see me touching it, but right here,
So it is a touchscreen. Did he activate the touchscreen or should it?
I think it's already active.
Ooh, magnify.
oh, cool. All right. So right about here is where Winding River turns into Dogwood Road. And I want to say right somewhere between here and here is where the incident happened. Like, right, because around this curve,
You would tap the screen briefly. And then see that pencil in the lower left-hand corner? Tap that pencil icon way over in the corner.
oh, okay.
Now, when you touch it, it should draw.
Okay, so somewhere around here is where the incident happened. Because I just made it around the bend where you could see, where you could look down on 400.
Were there any noticeable buildings in that area that you know about that can help orient us? Where on the road might be?
There was like a water station or something along that road on, I want to say the right-hand side
Okay.
where I was walking. I feel like I landed maybe, I don't know, like 30, 40 feet away from it.
Okay. And so let's back up one moment. You're walking along the road. Where are you? So there's a road. Where are you? Are you in the road or are you on the side of the road?
I was on the side in the grass.
Okay. About how many feet from the road were you?
Maybe a foot
Okay.
and a couple inches. Like there, unfortunately, at that particular point, there wasn't a whole lot of grass to be over in, because like I said, it was overlooking 400 and there was just a big hill going down there, you know? So I didn't want to, I would have tried to slip down and fall into the highway, you know? But yeah, maybe like a foot.
Okay.
Yeah.
Okay. So you're walking a foot in on the grass, right?
Mhm.
And are you just walking in silence? Are you doing anything as you walk or?
No, I was just walking. I had my headphones in,
Okay.
so I didn't hear them coming. I didn't see them coming.
Did you, okay, just before the incident, did you see any lights or anything? Like from behind you?
Not that I can recall, but you know, like I said, I was kind of in the zone, just trying to get home, you know.
Okay, so you're walking. Do you ever stop to look at your phone to check the time at all?
Not, I feel like I had right at the intersection where, right around here where Winding River turns into Dogwood Road. But after that, no, I don't think I have. I was just, like I said, I might have checked my phone to change the song or something. But from there, I was just trying to focus on getting home.
And when you checked your phone, did you notice the time at all?
I feel like the last time I checked my phone, it might have said like 4:12 a.m., something like that.
Okay. Okay. So if it was about 4:12 a.m., How much time do you believe you had walked up until that point
From,
from the North River Tavern?
30 minutes maybe.
Okay, okay. So is it fair to say you probably left North River Tavern about 3:30-ish?
Yeah, that's fair. Yeah, that's fair. Fair guess.
Okay, okay. So it's about 4:12. You don't hear anything because you have headphones in. Didn't use it. What happened to you at that point?
At that point, I just remember flying through the air and then blacking out. And when I came to, I tried to sit up. I was obviously a little sore. And I noticed I couldn't really move my ankle at all. So I tried to sit up and scoot myself away from the road. And thankfully, my phone was still in my pocket and still working. So I ended up, I looked around. I've lost my glasses also. So I couldn't see that well, but I looked around. I didn't see any cars pulled over, nothing. So, I pulled out my phone. I called 911 myself.
Before you got here, you say that you passed out. How do you know you passed out?
How do I explain this? I mean, like I said, I remember flying through the air, but as soon as I hit the ground, I had to have, blacked out. Because like I said, I didn't see any cars pulled over or even rolling by or anything, So it was just, I kind of assumed whoever it was had left. I didn't see any other cars around or anything. And I remember sitting up, so I'd been laid out for at least a minute, like getting hit by an SUV. I would assume most people would probably, black out, although it might have been the whole broken ankle thing. I don't know, but I remember sitting up, the feeling of regaining consciousness, if you will, and not really knowing exactly where I was for a second, thinking
So you had symptoms that made you feel like you lost consciousness.
Yeah.
Were you dizzy at all?
Yeah, a little bit, yeah, probably.
Okay. You wake up, you're on the side of the road, push yourself further. Do you know which direction you went in? Did you go sideways? Did you go forward?
And really, so let's say I got hit right here and I went a little bit that way. So along the road, but thankfully not over the edge down, towards the highway.
And are you certain, and at the time you were hit, where were you standing in relation to the road?
I was on the right side, kind of off into the grass, about a foot, so.
Okay, so still in the grass.
Mm-hmm.
So Mr. Duffy, I need to make sure when you're answering questions, if it's a yes or a no, instead of going, you say yes or no, because the court reporter can't take down,
Yeah.
I understand exactly what you mean, but the record will be, I don't know what he said. So just make sure if it is a yes or a no, and you're being asked to give expository answers, so give full sentences, that's great. But if it's a yes or a no, just make sure you give us that, okay? Thank you.
So let's move forward. You wake up. Do you, before you call the police, do you check yourself for any injuries or anything?
Not really, no, sir. Because like I said, I sat up and, I noticed I couldn't really move my ankle how I should. So that was the point I realized, all right, at the very least, my ankle's messed up. I didn't, like I said, I just come to, so I didn't really think about the fact that it was probably broken, but I scooted myself away from the road and then, kind of patted myself down, found my phone was still on me, still in working order, and immediately called the authorities.
Okay. And before you made the 911 call, this may be obvious, but how are you feeling at that time? Like, were you, well, I'll let you answer this one.
I was feeling a lot in that moment. Frightened for sure. Because, I guess up to that point, I'd done an okay job keeping myself calm until I got on the phone with the police. And at that point, another car rolled by and I kind of started freaking out a little bit, because I was like, I can't, it's like, I can't really move. I ain't trying to get hit again. Like, I was feeling upset for obvious reasons. I was supposed to be off for 2 days, I was going to have, gonna play some video games and stuff, and ended up spending like the next almost week in the hospital. But yeah, I didn't really think about it too much at the time until I made it to the hospital. But I was, kind of angry that someone could do that and just leave.
So you called 911. Do you remember that phone call?
I remember very vaguely. Like I said, I remember calling 911, another car rolling by, and kind of freaking out, and the dispatcher happened to be like, calm down, I need you to tell me where you are. And they actually pulled up like really fast. Like, I want to say they were there within 5 minutes of me calling.
If you heard your voice on a 911 call, would you be able to recognize it?
I would think so, yes. Yes, sir.
Oh God, I think my leg's broken.
You recognize that voice?
Yeah, that sounds like me.
So you're not gonna, this is not an evidence, so we shouldn't be hearing any of this beyond that little bit because there hasn't been an objection, but there will be, it looks like, if you're gonna play any more without tendering it.
I will not, Judge.
Okay,
I just wanted him to recognize his voice.
okay. Was that your voice?
Yes, sir.
Got it.
Judge, based on the certificate of authentication, as well as Mr. Duffy acknowledging his own voice, the state would ask to tender into evidence the 911 call that was made that evening.
Okay, so the business records you submitted, obviously you couldn't file the 911 call. The paper that went with it, you said accompanying it, at least provided to the defense, would have been the audio of the 2 911 calls we've discussed.
Yes, Judge.
Okay, and would this be states 2?
Yes, Judge, you would. Thanks to
Ms. Wood, do you have any objection to the admission and subsequent publication of states 2, which is the 911 call that Mr. Duffy made?
Judge, just to clarify, you're admitting the actual call or just the CAD report?
the call.
No objection.
Okay, so S2, which I will add to my evidence list here, is the recording of the 911 call that Mr. Duffy made. It's admitted and you can publish it.
Yes, sir.
911, what's the address of the emergency?
Hi, I'm on the side of the road. I just got hit. I just got hit and run on.
Okay. What's the location where you are? What's that location?
Fuck. I was leaving North River Tavern. I'm on sorry, I can't. I'm trying to think real hard.
Okay.
It's not Winding River, but the next road down. By the water, by the river raft. On the Chattahoochee, and oh God, I think my leg's broken.
I can get you some help. I need you to tell me exactly where you are. Do you see anything around you? Any street signs? Any businesses? Anything like that?
No, I don't. I wear glasses. I don't know where they went, man. Oh, fuck.
Okay.
Oh, I can't afford this. Oh, fuck. Okay. Fuck. You know where North River Tavern is?
I do. Yeah.
All right. So I went, I believe, southbound across the bridge, across the Chattahoochee, and then I took a right across the smaller bridge, heading towards towards Holcomb Bridge Road.
Okay. Okay. What's the telephone number you're calling me from?
404-449-3761.
Okay. What's that telephone number? One more time for verification.
404-449-3761.
Okay. Your name?
Matthew Duffy.
Okay. Okay, Matthew.
Oh, Lord.
Okay. Tell me exactly what happened.
I was walking home from work and some dude on the sidewalk, and some dude just fucking quit me, and I don't know what happened, man. I'm so tired. I've been on my feet like 9 fucking hours. Oh, I'm like I'm fucked. I didn't get a look at the car, nothing, man. Oh no.
Just for clarification, are you in a vehicle yourself, or are you on foot? Okay. Okay.
This fucking bullshit. I'm fucking too still messed up.
Okay. All right, we're gonna get you some help, okay?
Okay.
Yeah, I want you to keep talking to me, okay?
Oh God, there's no fucking stars on this, please.
Okay.
Oh, I was just trying to go. Oh, I can't even fucking hobble away from the road, man. I'm so scared. I'm sorry. It's the matter. I need me. I can't fucking die right now.
No, you're not gonna die. We're gonna get you some help, okay?
Oh, like, I want to try and get away from the road, but my leg hurts so bad. Oh God.
It's in progress. He just got hit. All right. When did this happen? How many minutes ago did this happen?
Fuck, it's 4:22. I don't know, like maybe five minutes ago. I think I blacked out for a minute, but I don't know. I don't know, man. Oh. 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 Bullshit.
Okay.
Oh. I'm trying to calm down.
No, you're fine. Just are there any dangerous conditions present?
Hey, what?
Are there any dangerous conditions present?
I'm not sure I can tell. I'm kind of in a dark spot, man. I don't know. I'm kind of like in between two fucking streets. I'm kind of in between two fucking streets, right?
And
Hold on.
How did the person leave? How did the other driver leave?
I don't know. They were heading the way I was going towards Oakland Bridge.
I need to get the vehicle. I need to get the vehicle description if you can.
24, red 24 battalion.
I couldn't see it, man. Like I think I blacked out for a minute.
What direction was he going?
He was heading towards Oakland Bridge on the road that leads the big hill next to the Crystal on Oakland Bridge.
Okay.
Oh, my fucking tooth is fucked up, man. Fuck.
No, he blacked out. He didn't see the vehicle. It hit him from behind. I need to get the suspect or the person's description if you can. Were you able to see the driver?
No, man. Like I all I remember is getting brought the fuck down. Like I may have flew through the air. I'm not sure. I really don't know, man. I don't know.
Okay, he's just south of Grimes Church Road on Dogwood.
That's the one. The old Dogwood. I just gave it past Old Dogwood Road.
Okay.
Oh wait, no, not that. Old Dogwood's the one that goes up to
What are you wearing, sir?
Tan hoodie. I was wearing a hat, khakis. I see some police lights.
Okay.
I think they're turning the wrong way.
Okay.
Oh, God damn it.
No, they're coming to you. Which side of the road are you on?
I don't see him anymore. I think I'm on Old Dogwood.
Okay.
I think he turned towards Old Alabama.
Okay, do you see the blue lights?
I did, but they turned.
I don't. He did, but they turned. He doesn't see them now. Which side of the road are you on?
He was coming towards me, so I'm on the opposite side. And it looked like from where I'm sitting, it looked like he turned left.
Okay.
Oh.
He's on Dogwood between Grimes Bridge and Riverside.
Okay, I'll see him again.
He's on Dogwood, just south of Riverside. He's south. There he is, right there. He's south of Grimes Bridge on Dogwood between Riverside and Grimes Bridge.
All right, this sounds me. Thank you.
Okay, very good. I'm going to let you talk to them, okay?
All right, thanks. Oh.
That's it, Judge.
Okay. Mr. Duffy, you doing okay, or you need a break?
Okay.
You okay? All right.
Mr. Duffy, that was a fair representation of what occurred that night when you called 911.
Yeah. Well, admittedly, a little more dramatic than I remember, but you know.
Can you describe for the court all of the injuries that you were feeling in that moment? I know you mentioned so far your ankle, but what felt hurt?
At the time, definitely my ankle. My chest was real tight. I felt that whenever I initially had tried to sit up. I didn't really notice too much going on with my head until I got to the hospital. You know, I'd ended up, I think overall there was the broken ankle.
Well, just focus on what you felt that night when you were hit.
Yeah, just the broken ankle and the bruising on the chest, definitely.
Any other parts of your body felt hurt or injured in any way?
Not that I noticed right in that moment.
And after the 911 call, what happened? As far as what you observed and if anybody arrived?
The police showed up with an ambulance. Thankfully, they found my glasses. They got me on a stretcher, got me in the ambulance. I've been wearing a backpack, and I guess I lost that too. So they had to find my backpack for me before the ambulance took me to the hospital. When they got there, I told them the same thing. I got blindsided from behind. I never saw them coming. So, I don't know. I didn't know what to tell them to look for. Didn't get a look at the driver or nothing. And I feel like after that, they went ahead and carted me off to the hospital.
Okay. And did you have to have any surgery at all while you were at the hospital?
Yes, sir. I'd had surgery on my ankle.
Is that the only location?
Yes.
And how long was there a recovery period after the surgery?
Yes. The recovery period was, I want to say it was originally supposed to be 4 months. Like after the surgery, I was supposed to wear a cast for about a month, maybe a month and a half, something like that. And after it came off, I was supposed to take it easy for about 3 months, 3 additional months to, build the strength back in my ankle, start using it again.
Did you do that?
Yeah, I actually ended up going back to work about a month early, just because I really was trying to get some semblance of normality back, and I felt like I'd done a decent job of recovering, but I probably should have stayed out of work that extra month. But fortunately, the assistance I had been getting while I wasn't able to work had kind of run its course as well, so I didn't have a whole lot of choice in the matter.
And what was that assistance?
I've gotten some help from this, I guess you would call them a assistance program, the Giving Kitchen. They kind of, they specifically help out people in the food industry that are having a hard time making ends meet. And I'd also set up a GoFundMe with the job at the time in North River Tavern, and a lot of my coworkers and some of the bar regulars had been donating, but after a while that started drying up, so I had to go back to work.
And you're just describing the support you got before you went back to work, correct?
Yes, sir.
Did this affect your family life at all?
A little bit, yeah. My boy, my boys for a while, every other day were asking to get hit by another car when I hadn't even left the room in in days. And I'm just like, no, I did not get hit by another car. Been here this whole time. My girlfriend, she for longest was almost literally working just to pay for Uber or Lyft for me to get back and forth to work. She was like, you're not walking anymore to work. It's like, or at least not walking home from work anymore.
Last question, Judge. Mr. Duffy, when you awoke after being struck, there no cars around you whatsoever?
None whatsoever.
Were there any individuals walking by at all?
I was the only person I'd seen on the road. Usually I am the only person on the road that late at night, you know what I mean? But, when I came to, there was no one around at all. I didn't see no headlights or taillights disappearing around the corner or nothing.
Thank you, Mr. Hand. Ms. Wood, questions for Mr. Duffy?
Judge, we have no questions for Mr. Duffy. Thank you for being here, sir.
Thank you, Ms. Wood. Ladies and gentlemen, if you've got any questions, now would be the time to jot them down on note cards. If you don't, that's okay too. Should Deputy Gordon, are there any questions? Okay, we'll play the kind of Jeopardy music for a minute, and Deputy Gordon will collect those in a sec. Thank you.
There's my apologies. I forgot to ask to physically publish the exhibits to the jury.
I'm not sure what you mean.
There's a picture of map, which is stage one,
Yeah.
scale with the witnesses. I was just going to publish it to the jury physically, but.
Okay, if you mean like pass it around, we don't do that anymore. That's one reason why we've got the big screens. It is an exhibit. It will go back with the jury, so they'll be able to look at it during their deliberations. But unless it's something that actually needs to be manipulated by the jury to effectuate the witness's testimony, that's why we've got the big screens. So S1 and S2 are now both part of the record. S2, they'd have to ask to listen to again during deliberations, but S1 will be with them during their deliberations. Okay. All right. I'm going to ask you all to sit tight while I talk with the lawyers about these questions. Mr. Duffy, I'll be back in just a minute. Lawyers, if you'll come this way, please. No problem. Waiting too long.
I'll stand up and stretch it out.
Mr. Duffy.
Yes, sir.
You're wearing glasses. Are you farsighted or nearsighted?
Nearsighted.
And when you say nearsighted, do you mean it's hard for you to see things up close or the reverse? You can see fine up close, but you'd have trouble seeing the gentleman with the yellow tie and the blue jacket.
Yes.
So when your glasses aren't on, you could see me, but you might have trouble seeing things far away.
Yes.
Got it. What were you wearing, as best you recall, the night you were hit?
Khaki pants. I think I might have been wearing one of my work shirts, like a NRT shirt, which would have either been solid black or gray.
It's December, so were you wearing any outerwear over the work shirt?
Yeah, I probably had a hoodie on, but I can't remember. I can't remember if I still have that hoodie.
More importantly, you don't remember what color it is?
Yeah.
Okay, khaki pants, a hoodie of some color.
Yeah.
Okay.
I do remember the book bag I had at the time. It was kind of a lighter blue color and had like little reflectors on it, you know.
Okay. And that would have been on your back before you got hit. And then I think you described you and it were separated.
Yes.
Okay. Had you been drinking at all that night?
I probably had at least one beer.
Okay. And with that,
I know I had one on me because the way it worked at North River Tavern, we would get 2 shift drinks after we clocked out. I would usually drink one there, take a can with me, to drink when I get home.
okay. So the beer that you did drink would have been during that 2-hour window of we're shutting down and cleaning, and you weren't playing pool, but people were playing pool.
Yes.
Okay. Which ankle was hurt, right or left?
Left.
And which pocket was your phone in?
I want to say it was also left pocket.
Do you remember blood anywhere?
I don't really know. I mean, I'm thinking I probably should have tasted blood, but all I can remember tasting is dirt.
How would you describe the lighting where you were walking at the time you were hit?
Not great. Honestly, not great at all. Like I feel like after the fact, almost 2 years later, they might have put an extra street lamp there or something, but no, I feel like I was maybe just outside of the reach of the nearest street lamp.
Okay. And when you were hit, were you walking on the street, as in Dogwood Road, wherever street you were on, or were you walking on the side of the road, i.e. grass or gravel or?
On the side of the road.
Okay.
Like in the grass. I would have been over further, but maybe I had like maybe a foot of grass between me and Dogwood Road on this side, and on the other side was maybe another foot before the drop to 400.
Got it. But on either side of you was grass and not street.
Yes.
Mr. Hand, do you have any questions based on the exchange I had with Mr. Duffy?
Yes, sir. Pretty quick. Mr. Duffy, you mentioned that you had a beer either before just before leaving. Is that right?
Yeah.
Okay. And what size was it?
I want to say it was maybe like a 16-ounce can.
And how much would you say you weighed at the time?
I don't know, like 230, 240.
And before you were hit, did you feel intoxicated at all?
Not really, no.
Is it yes or no?
Like I said, I'm a heavier dude, so takes a little bit for me to actually, start feeling the buzz. One beer is usually enough just to, relax after pumping out food for 8 to 9 hours, But no, I don't recall feeling intoxicated. Just like I said, I was walking home after an almost 8-hour shift. So if anything, I was tired.
Okay, thank you. Nothing further.
Ms. Wood, anything else for Mr. Duffy?
No, Your Honor.
All right, Mr. Duffy, thank you for being here. You are free to go. Appreciate your time.
Thank you.
Ladies and gentlemen, we're going to take our morning break. It's a little later than we normally would, but we started a little later because of traffic and weather and all that. I'm going to try to keep it to about 10 minutes. During the break, feel free to use the jury room. You also can use that back hall. That is Judge's Hall, so no loud noises when you're back there, or my colleagues will fuss at me, but as long as we maintain that contract. Some folks like to walk all the way down. There's a window where you can look out and see the rain, but feel free to fan out in the hallway, use the jury room, the restrooms, and I'll have Deputy Gordon get you all in about 10 minutes, and we will continue with the state's presentation. We need to break for lunch no later than 12:30 because I have to get on a Zoom call, ironically, about jury management software, so we can make your experience on the 7th floor more pleasant next time you're here. Don't talk about the case, no outside research. When you've got questions, this is how you do it. Great job. Thank you, everyone. See you in a few. Will you remind them to have their discussion about masks? Thanks. Mr. Hand, anything from the state before we break?
No, Judge.
Is Ms. Newborn coming up before lunch?
No, Judge.
Okay, I ask only because we need to talk about the texts. No one warned me that the text had pictures. It's all right. County computer, I'll explain it when I get called by the JQC. Anything from the defense before we break?
Your Honor, I apologize for not flagging that for you.
That's okay. They got flagged pretty quickly. Let's be back close to 11:30. We'll try to get folks in. We get an hour for lunch. Don't worry. Thank you. Hello, Ms. Primovic.
Good morning.
Good to see you.
This is the short. What time are we gonna be back?
Like 7 minutes, 11:30.
Stay all night.
Did you need me or?
No.
Good, because then I'm leaving.
Okay, good.
We need.
Seriously.
It's like, she called me, I was like, what's up? Yeah. Like usually she calls me when there's some group of kids she wants me to talk to. So I was expecting that to be the answer. I was like, I need about 10 minutes. So she was like, can you get, she's like, Liz is, well, I'm like, oh, I'll be right there. You know, you're not in the mood for bullshit. He brings up. All right, but I'm gonna go do other things. I'll be back later on today. They're going all the way to the office. I'm sorry.
There's like multiple, or is it just?
Brittany was, but they went on Frost.
Kate, or Kat.
It's supposed to be on Friday. There's that. But here's the good news. They're not gonna bother Liz with it.
When I saw her and she was acting like she wanted to talk, I was like,
Shit.
and then she said that and I was like,
Good day to bail on duty. Who was the dude, who'd you say, what was his name? Shit, who's the duty person who was bothering?
oh, David Houston, I don't know. He's gonna say what he's doing. He's there.
You're awful. I don't even know what you said. All the text. Sorry for the warning, Judge.
Well, you didn't warn me either. I was just flipping through.
Boing.
You recognize that?
Whose would that be? Is it a fair and accurate?
That's what's in Sue.
All right.
Thank you.
I'll be back later this afternoon because this is a lot of fun. This will be a hard too.
Is that cool?
Yeah, it is.
Amazing.
I'll be back later on. Always good to see you, sir.
Always great to see you.
I'll see y'all later. Here.
See ya.
Yes.
I like that coat, that trench there.
Cute. I just want here so Pierce can comment. Make me feel good. Thank you.
All right, how you feeling? Okay. That's B. Oh, gee.
Hey, Snaps.
Hey, how's it going?
Good, how are you? I'm doing it. Safe. Okay.
So. Any questions? Real quick.
Oh my gosh.
Mm.
Is the tower ticket on? It wasn't logged in. Yeah. Oh, it is. Yeah. I'm sorry, I didn't CC you. I emailed you. Yeah, thank you so much.
Thank you.
Problem solved? Okay. Ms. Rivers, you ready? All right, let's get back on the record in State versus Christopher. Anything, Mr. Hand, before we bring the jurors in? Your next witness is?
Officer Brake, Omar Brake.
Brake, okay. Ms. Wood, anything from the defense?
No, Your Honor.
All right, let's bring the jurors in and let's have the officer right outside. Please.
All right, adjourned.
So the one thing, if you are mixing it up, try to slide all the way in when you take a seat, because someone's going to need to walk across all of you to get down to the end. Uh-oh, now that row's full. You guys, careful. All right, no, mixing it up is great. Just when you walk on in, just come out first and take the furthest seat. Come out last if you don't want to go deep in the row. All right. All jurors are still playing musical chairs. Welcome back. We are continuing with the state's presentation of its case. Mr. Hand, if you'd call your next witness, please.
Yes, Your Honor, the state calls Omar Brake, officer. Omar Brake.
Raise your hand. This is what affirm that the testimony will be able to truth, the whole truth, and nothing but yourself. I do. Go ahead and have a seat. State and spell your name for the record.
My name is Omar Brake, OMAR BRAIK.
Officer Brake, how are you doing?
Well, and you?
I'm doing well. Still morning. Where are you currently employed?
Roswell Police Department.
Okay, were you employed there in 2020?
Yes.
December specifically?
Yes.
Okay, and what's your title in with Roswell PD?
Currently, I'm a detective with the Crime Suppression Unit.
And is that a new title or was that
Yes.
your title? Okay, what was your title in December?
I was a patrol officer.
Okay, and what's the difference between just patrol officer and detective?
It's more so now I do narcotics, gang, stuff like that versus just regular patrol.
Okay, and how long were you on patrol as the patrol officer before transitioning to?
I was there about 4 years.
Okay, in total. Okay.
Yes.
And how long have you been a detective thus far?
About a year.
And what are your duties? Let's start with as a patrol officer. What are your duties?
Just answering calls for service, patrolling the city.
Okay. And are there any specific types of crimes that you would be involved in?
No, we did all types, from shootings to car accidents, to anything.
Okay. And that would include hit and runs, right?
Correct.
So is there any special training that you have related to hit and runs at all?
No, sir.
Okay. So you just respond when it occurs and.
Correct. We take the initial information and then pass it off to the traffic unit.
Okay. What does the traffic unit do?
I don't know.
Okay.
They continue the investigation from there.
Okay. Okay. But you all are just the first responders.
Correct.
Got it. Okay. Are you post certified?
Yes.
And if you are, can you explain what that means?
I passed, so I'm certified through the state of Georgia to be a sworn police officer.
Okay. And is there any training that goes behind that? And can you explain what that?
We go through the academy. It's 13 weeks. And then from there, we continue our training. We can go to different specialized classes and stuff like that, going through post.
And so after your specialized training, you have been on the job for how long until December 2020?
I was there about 3-4 years, 23 or 4 years.
Okay. And so let's talk about December 12th. Were you working that day?
Yes.
Okay. Do you remember responding to a hit and run incident?
I do.
Okay. Do you remember the location or estimate of the location where that incident occurred?
It was around Grimes Ridge Road in Dogwood.
Okay. And is that in Fulton County?
Yes.
Were you the first, did you eventually go to that location?
Yes, I did.
Okay. And were you the first officer there?
I don't think I was the first officer. I think I was maybe second or third. But I think I was one of the first ones to make contact with the victim.
Okay. So how'd you get there?
In my patrol car, lights and sirens.
Okay. And once you got to this location at Grimes Road and Dogwood Road, what did you observe?
There was a male on the side of the road. He was bleeding from his mouth. His pants were kind of down, like he'd been struck. There was what appeared to be a beer can that was smashed, like somebody hit it. And I checked with him. I think he said his leg was broke or his leg was really hurt. And again, he was bleeding from the mouth.
And when you say the beer can looked like it was like someone hit it, can you explain what that means?
So it was like exploded. Like I guess the best way for me to describe it is like a high velocity impact on like a can, the way it explodes.
And were there liquids anywhere on the ground or at all?
So there was liquid from the beer near him, and then it appeared that there was a vehicle like that was leaking some type of fluid that was leaving from where he was.
Okay. And did you ever determine what that was or?
No, I didn't.
When you routinely respond to hit and runs, is it routine to talk to the victim who's there at the scene?
Yes, it is.
And did you talk to Ms. Duffy at the scene?
I believe I talked to him very briefly.
Okay. You didn't have to go into what he said.
Yeah, it was very briefly.
Okay. And while you were there, did you observe, what else did you do after talking with Ms. Duffy? Anything?
We just waited for the ambulance to get there because I didn't want to move him because of his injuries.
Okay.
I think he was missing his glasses at the time, so we got him his glasses and then just kind of stood by with him.
Did you look around the area at all?
Yeah, we looked around, see if there was any parts. I kind of followed the fluid trail up to the other side of the road, but I didn't see anything. I think at one point I thought I might have saw a car back in the woods, but it wasn't. It was just a big branch. But that was it. There was like a couple pieces of like parts missing from a vehicle that were from a vehicle on the side of the road.
And how did you know that there were parts of the vehicle? Is there any indication?
Usually there's like part numbers and stuff like that on the back of them. And I want to say that somebody else found a mirror, but I'm not 100% sure.
Okay. Did you, while you were there, observe a mirror?
I believe I did.
Did you observe anything other than a mirror?
There was also a piece that looked like it came from a bumper.
Can you describe what that piece looked like?
It was like almost like a triangle shaped piece. It was silver, like a plastic bumper piece.
Okay. And you mentioned someone might have found the mirror. Was that mirror useful at all for the investigation or folks?
At that time, I don't think so. I believe it was collected by traffic later on when they came out, but I don't know. Due to it being a serious injury accident, we pretty much just held the scene and waited for traffic to come out to investigate it because they always deal with serious injuries and fatalities.
Okay. And how would you characterize, what would make this a serious injury?
Like broken bones, stuff like that.
Were you wearing body camera footage?
I was.
Body camera?
I was.
Did that body camera catch footage of what transpired when you arrived on the
Yes,
scene?
I did.
Right. Judge, may I approach? Oh,
You may.
again, thank you. Do you recognize this?
Yes, I do.
How do you recognize it?
It's the disc that I watched earlier of my body cam
How do you know it's your body cam?
because I signed it.
So is that your signature on it?
Yes,
You have viewed it, acknowledging it's yours.
yes, I have.
Judge, the state will move at this time to ensure officer breaks body camera footage.
All right. I'm on number 3. Is it labeled as states 3? Not the disc, but the,
Have a label.
okay,
But it is.
got it. Any objection, Ms. Wood, to the admission and publication of Officer Brake's body cam footage?
No, Your Honor.
Admitted?
Judge, for the record, just because a good 4 minutes of this is him driving, the state would start at marker 4 minutes in.
I was about to sneeze. Great. The video is in. You're free to play any part of it you want. And then if Ms. Wood wants to complete it by playing another piece, she can. But you can start it and stop it wherever it is you want to do so.
Okay, will do, Judge. And this will be about 18 minutes.
Everything okay?
Yes, Judge, I just didn't share the sound as well.
I'm out with him. I'm south of Grimes Bridge. headlight.
That one.
Your headlight. So are you okay? Where you get hit at?
I got hit from behind.
Okay. You have a possible broken leg. Where's your leg hurt at?
Like,
Okay. All right. Hold on 1 second. All right, man. Just do me a favor. Just keep talking to me. Huh? Glasses. Hey, bud. What's your name?
Matthew Dusty.
What's that?
I'm Matthew Dusty.
Yeah, they're right in front of you, bud.
Oh,
Yep.
thank you so much. Oh, fuck it. How I go out?
Yeah, your mouth's pretty messed up, bud.
Fuck. South.
Coming this way, yeah.
Which way? South.
Yeah.
South, most likely.
Because it looks like. Because I saw. That's when I first noticed that he was over here. Because I saw skid marks. Did you tell him it's going to be missing a mirror? There's not a car back in here, is there? But it looks like he came, like if you look at the skid marks, it looks like it's coming this way.
And was he standing there?
Hey, I may have the vehicle over here. Oh, it's a branch. Those aren't skid marks, those are fluid marks. Because there's like fluid marks up there.
Yeah, he said he was walking this way, car hitting from behind. And it makes sense, that's the passage side north.
Yeah. No, it would be up here. He said he's going to Dogwood and Riverside. No, it'd be this way. Is this his beer can? I initially thought I had the car up in the woods, but it's just a branch that's like folded over and it literally looks like the top of a car.
Does it?
Yeah. I was like, what? I get like overcorrected and you see like fluid up there.
There's lots of parts I'm looking for something to look in on.
They're probably gonna be the stretch right here. And so we'll help you stand up and we'll get all that weight on the right leg so you can turn around and sit down and stretch, okay? Back, help you stand up. What do you think? You don't know?
Does he say he has an ID or anything on?
I got it.
Huh?
I didn't even know.
You want me to take it?
What is anything else hurt besides that leg? Well, I'm here, he's here. We have the one three of us we can get up. I've got this one, he grabs the other one and we go for it. What do you think? All right. Y'all bring the stretcher right here?
We'll wait for the stretcher, okay?
Yeah.
It's an ambulance, right? You got one?
I was thinking the same thing.
We're gonna turn around so we can sit back on the stretcher, okay?
We just gotta make it there, okay, Bob? Doing great. Which way should I turn? Left or right? You're gonna turn towards me. Up here first. Let's talk a little. Ready? I got you. Go ahead. There you go. That's great. There we go. All right, we're gonna turn towards me.
Almost there. Right there, that's it.
Yeah, it's fun. Wouldn't be surprised though.
What?
Ankle broken.
Oh yeah, that's definitely broken.
massage that leg. And your mouth. Hands. Okay. All right, you want to keep the feet up here? We're going to let you move your leg and move the couch, okay?
I don't know if that's his beer or their beer.
I want to pause it right here, Officer Break. Do you see what's happening right now in the video? Can you describe what's happening?
I believe Sergeant Fortunato just found a piece of the body panel to the vehicle.
Is that why y'all were searching in the bushes? Okay. Is that the panel you were mentioning earlier?
Yes.
Okay. And who's the individual holding it?
Sergeant Fortunato.
Okay. Does he know, strike that. I'll play the rest of it.
Whatever that yogurt is on it. So there's no numbers on this one.
Yeah, because there's
probably was yogurt or something like that. Smash in that
and a beer.
Beer or whatever else.
That's what I'm doing. I'm going to copy this.
He got pretty messed up mouth and then his ankle. I think his ankle is going to be broken. I think his ankle's broken.
Oh yeah, that's not good. Did he get hit or his fall?
No, he got hit.
Really?
Yeah, like there's a mirror right there.
Toyota Highlander. He's doing pretty good for being hit by a car. Especially probably flying pretty fast around me.
Okay.
But if you want to do crashing and stuff and help around with it, definitely just go stand on take it to the right. Okay. 1 second, can you picture it?
Does he have the drone already, or should I run back and get the drone? Because they may have to map it.
I don't think he's awake yet. Ruff is just now calling him.
I'm about to make sure he's up.
I'm sure he doesn't have it already. Huh? I picked up something that had that yogurt on it. You got to put the towel or anything? I think
I got a rag we can throw away. I mean, I don't care. I got a rag. You want it? Like a microfiber rag. Yeah. Like they get here and then they sit in the car for like 5 minutes.
I'm staring at it. Are we gonna go or do you want to fuck off?
I was like, are you kidding me right now? Thank you though.
Thanks, buddy. Yeah, bud.
So once all these little pieces in the road, we could open the road. But then we want to mark exactly where they are. On the phone, I'm holding with radio for, at this point, 3.5, 4 minutes. They finally get back to me with who's on call, and they say, Lewis, break. And I was like, that's the crash team.
You really got the wrong thing.
They just read it off as Bailey. And he's like, oh, hang on a second. Puts me back on hold for another minute. Yeah.
Tim, get your act together.
All right, Judge, I'll start it there.
All right.
Officer Brake, or the EMS arrived to treat Mr. Duffy. What injuries did you visually observe?
Just his mouth looked like it was busted. I mean, I didn't pull his pants or cut his pants to see if his leg was compound fracture or anything, but just like there was blood coming from his mouth.
Okay. And what were the items that were actually found at the incident? You mentioned the bumper.
I believe there was a mirror, a bumper, and one of the pieces Sergeant Fortunato had fluid all over it, like some kind of like automotive fluid. And then there was, I think he had a couple items like the beer that was exploded, and then maybe a couple other drinks.
When you say bumper, is that a different thing than what Sergeant Fortunato was holding up, or?
No, sir, it's a piece of the body.
What he was holding up, you say was a piece of the body, but separately, and maybe we didn't see it in your body cam. There's actually a bumper from the car, or a piece of a bumper?
It's that body piece is the piece of the car. That's what I'm referring to as a bumper.
As the bumper. So we're talking about the same thing. What
Yes.
Fortunato had that had the fluid on it, bumper, piece of body, all same thing.
Yes, sir.
Okay.
When you saw that out there, did you immediately notice it was a piece of a bumper, or just?
Not immediately.
Okay. When you first saw it, what did you recognize there?
I mean, it does look like a piece of, like, you can tell it's painted, but you can't tell like what it is. It's just a chunk of plastic.
Okay. Did you associate it with a car at all, though? Just because
Not immediately offhand.
Okay. At some point, you state that he was hit by a car. Was that just based off his statements, or was that your conclusion based on looking at everything?
I believe that's what he called it in as. He's the one that called us, I believe. And I think that that's what was said. And that's when he said that he was hit from behind.
Okay. So at this point, you hadn't made any conclusions yet. Okay. Got it. Okay. At some point, Mr. Duffy lifted up to put on a stretcher. Did you physically help lift him?
I think I stabilized him a little bit.
Okay. Did you think that he could get up on his own?
No.
And is that just based off your observation or more?
Just based off of my observation from the way the medical personnel was helping him.
And when you were on the scene looking around, as you did for, looked like at least 15 minutes, you looking around, did you observe any other pedestrian cars parked in the area?
No, I did not.
Did you observe any pedestrians walking by?
No, I did not.
Was there anyone in sight other than EMS and police?
No.
As you were driving up to the road, maybe right before you got to Mr. Duffy, did you see anybody?
I did not.
Did you see any stopped vehicles along the road?
Not that I remember.
Nothing further, Judge.
Ms. Wood or Ms. Feely, any questions for Officer Brake?
No questions. Thank you for being here.
All right. Any questions from jurors for Officer Brake? Seeing none, Officer Brake, thank you for being here.
Thank you, sir.
Appreciate it. Take care.
Thank you.
Mr. Hand, your next witness is?
Next witness is Officer Bath, Judge.
Bath?
Bath. Yeah,
Bath.
Bath.
Okay. We've got about 15 minutes before we break. I think it would make sense to get into it, or you're going to be playing a 30-minute video, and so that'll be choppy if we do that.
Judge actually would be playing a 30-minute video.
Okay, why don't we get started? But we probably won't start the video, but you'd have to lay some groundwork anyway. So let's get Officer Bath in here, and then we'll pause when we need to break for lunch.
All right.
Thank you.
We still affirm that testimony you will give the truth, the whole truth, and nothing but the truth alone. I do. Go ahead and state your name for the record.
My name is Officer Sean Bath. I'm with the Roswell Police Department.
Officer Bath, tell us where you were employed in December of 2020.
The Roswell Police Department.
Okay, so same police department that you're in currently. What was your role at that time?
At that time, I was a training officer. I was actually working beside Officer Lewis. He was my field training officer.
Okay.
Meaning you were a trainee at the time, being trained?
Yes.
And the guy you mentioned was training you?
Yes, Your Honor.
Got it.
And you're with him. Let me take a step back. What were your duties at that time?
At that time, I was in my third phase. So where you do have the field training officer beside you, you're given the ground to move forward. They stay beside you at all times. Should they see you may be falling back in an area, and they'll step in to help if need be.
How long had you been the officer at that time?
At that time, without hire date, that would be probably about 6 months.
Okay.
On the road and training.
You're newer to the job.
I'm very new, yes, sir.
Which is why you had a trainer
Exactly.
with you. Okay. And at that time, what were your run-of-the-mill duties, I guess, as an officer?
In Roswell, it's right across the board. I mean, you can be responding to physical domestics. You could be responding to accidents or just doing pullovers. It's right across the board.
Okay. And do you remember responding to a call on December 13, 2020?
I do.
And what call? What was the topic of that? In the evening, about 9 o'clock.
Right. I believe the call was criminal damage to property. Once we arrived and found out what was going on, it actually sounded like a hit and run. Would you like from beginning to end with this?
No, that's good.
Okay.
Judge, at this time, the witness has already testified that there was a 911 call to which he responded based on the certification filed authenticating that 911 call. The state would like to introduce it as state court.
The call or these CAD reports we've been talking about?
The call.
Okay. So states for, and this is not the call we've already heard from Mr. Duffy. This is a separate call.
Yes, Judge.
Okay. All right. Any objection to the admission of states for in its publication?
We would object to lack of foundation at this point.
Okay. No, go ahead and respond.
Judge, officers don't just show up on the scene. They get a dispatch from 911 and that has to connect to a call, or mainly it's a call. And so this officer has already testified that he responded because of that 911 dispatch.
Dispatch versus call, though. You're trying to tender the call that would have gone, I assume, to a 911 operator as opposed to directly to Officer Bath. So I don't know that he's laying the foundation for the call, but there's the business record certification. So I don't know, we may be talking at cross purposes. And so it is maybe something we need to sort out at lunch. So why don't you ask some other questions of Officer Bath things you want to explore, we'll table states 4. But we can talk about that outside the presence of the jury.
Understood, Judge. Thank you. Officer Bat, you responded to a call. Did you physically go to the location of the call?
We did.
Okay. Do you remember the location of the call?
I believe the church is called Pleasant Grove Church. It's where the parking lot was directly across from the church. It's more of a, I think, a gravel parking lot.
All right. And when you responded, you didn't respond to that?
No, I was with my field training officer, Officer Lewis.
Okay. And when you arrived at that parking lot, what did you observe?
Parked vehicles at the time. The 2 individuals that were approaching us that made the 911 call to have us dispatched out to the area. They approached us and began to tell us what had taken place that day.
Okay. Do you remember identifying the individuals?
Yes, I do.
Okay. Do you remember the names of the individuals you spoke with?
One was a Mr. Shepherd, and the other one was a Miss Newborn.
And when you say Mr. Shepherd, are you sure that's the name?
Would looking at your report help refresh your recollection?
It would, Your Honor. I do not have a copy of my report at this time.
Can you just quickly show Ms. Wood what you're going to be sharing with him, just so she knows what you're sharing?
Thank you. So my only question, I thought his report was like 7 pages. Is it included in here? That case number. Yes.
Take a look and then you let me know.
I apologize. It's I made contact with a Mr. Landon Christopher, and then a Miss Kayla Newborn.
And when you say you made contact with them, did you ask them what was happening and they responded to you?
Right. Like I said, we're there for a call to service. So the call was, once again, a criminal damage to property. Once again, once we're there investigating, since the vehicle's involved, what they were describing happened actually looks more like a hit and run. When we're responding to these calls, we are there to take down the facts of what has taken place and their statement from that point.
Okay, what was the object of the hit and run?
It was a
Of the property.
okay. It was a tan Toyota Highlander.
Okay. And when you observed it, can you describe the damage to that vehicle?
From the passenger side, it was the lower bumper, and then the actual above the front tire on passenger side was damaged in that area, and also a mirror missing on the passenger side door.
Okay. And did you observe anything on the ground below the car?
There was nothing below the car.
When you say there was nothing, what do you mean? There's no.
Typically, any car accident you go to, even hit and runs, when something is taking place and there's damage to a vehicle, you're going to find the damage. You're going to find some damaged parts laying on the ground, much like a mirror.
Right. And so that led you to believe that it wasn't property damage, what you said?
Well, at this time, like I said, when someone says criminal damage to property, but I see a vehicle's been involved and it looks like there may have been another vehicle that hit this vehicle, this is looking more of like a hit and run. Someone may have backed into this vehicle or ran into this vehicle and just left the scene.
Okay. At that time, did you have knowledge of the hit and run involving Mr. Duffy the day before?
I did. I was actually on that shift when that call went out.
Okay.
I did not respond to that call, but I do remember the call going out.
And were you thinking, did you make a connection with that event?
Given the description of the vehicle and what we were seeing at that time, yes, at that point, we were going to be investigating the vehicle further.
Were you aware of any items that were recovered from the hit and run incident the day before with Mr. Duffy?
I was told that items were recovered and that they would be checking the serial numbers on them. At the time of the investigation, I was not aware of exactly what was recovered.
And you said you spoke, did you speak with, you said you spoke with Mr. Christopher who was there? Correct?
Yes.
Did you observe anything about his body language or anything while talking to him?
Like I said, at this point in my training and that early in my career, I probably wasn't going to pick up certain things like what you would think of body language. I did ask him some questions. He'd already stated that he had parked the vehicle there at 10 o'clock that morning. The call was made at 9 o'clock at night. He stated that, I was at my girl's house, came back and I found this. When he's talking to me, that's when we're already trying to maybe investigate this a little further, given the vehicle and what had taken place the shift before or our shift before. So just speaking with him, when was the last time you drove your vehicle? Did you drive it in the past week? Of course. Does anybody else drive your vehicle? And he says, yes. And, questions like how often or when was the last time someone drove your vehicle or who was it that drove your vehicle? And he wasn't able to give any names in that situation.
Did you find that suspicious at all?
I do.
About speculating what it meant. Asking if you found it.
I do.
Okay. Did he tell you how he left that location that morning?
He was actually picked up by the other female.
And he told you he was with her all day. Did he say where he went?
I believe he said it was her house.
And did he say who dropped him off as well?
His statement was he drove the vehicle there, and that's where they met up. And then it was Kayla that drove him home to her place.
Okay. And there is the parking lot, right?
Yeah, where he left the vehicle in the parking lot. That's where she met him, and they drove to her place.
Okay.
We're going to stop there, given what time it is. So you can find that question. Ladies and gentlemen, we're going to break for lunch. Officer Bath, I'm sorry, we're breaking up your testimony with lunch. It's just sort of how the day has begun to flow. If you all could be back by 1:30, that would be great. You're welcome to get lunch and bring it back. You can eat out. You can eat as one large group. You can completely separate. You're not required to do this in any way. Deputy Gordon can give you some thoughts of where you can go. But it's a fairly limited radius since you need to be back here by 1:30 so that we can get going again with the rest of Officer Bath's testimony. Please don't talk about the case when you're having lunch with each other or anyone else. And again, no outside research. Any questions before we break for lunch? No? All right. Thank you so much. We'll see you back at 1:30.
All right, good.
Officer Bath, you can be back at like 1:25. So you're in place and we're in place. That would be super. Okay. Thank you so much. Mr. Hand, anything before we break for lunch? Ms. Wood?
There.
All right, other than Officer Bath, let's be back at 1:20. We need to talk about the 911 call, states 4. We need to talk about these texts and pictures and a couple other things. So let's reconvene at 1:20.
Thank you, Judge.
Thank you. Can you stop the screen share, please?
Yes.
Thanks. Oh, I can do it. Never mind. I got it. I'm going to mute the microphone in here so it will not project anymore since we're on
Thank you,
break.
Judge.
Sure.
It's Fortunato.
Okay. Yeah, I'll let you know.
I'm just gonna leave everything except for one notepad in my computer.
Yeah, I'm gonna do this.
All right, Ms. Rivers, are you ready? Great, Master Malcolm, don't leave. The state can't be unrepresented. As long as you stay in here.
Here.
All right, let us get back on the record in Mr. Christopher's case. It's a little before the end of our lunch break, and Mr. Christopher is here with his lawyers. The prosecutors are here. Got Officer Bath back on time. Thank you, sir. So we have a little less time because I got stuck doing something. Let me cover one request directed at the state right now. It may apply to the defense later on. The two of you at the table. So if one of you is questioning a witness and you know you're going to need something played on a screen, if the other person sitting there could get it set up, that would save us time. There's been a fair amount of jurors looking at their knuckles while you're trying to get the body cam playing, but your trial partner could be getting it up because you've communicated, hey, with this witness, I'm going to do that so that it's ready for screen share. Same with the defense, should that come up. The texts, would we be, is Ms. Newborn likely to testify this afternoon?
I don't think so, Judge.
Okay.
Maybe late or.
Okay. You've got enough witnesses to fill the day, though. It's not that, I'm not sure we can get her here, and so we're going to stop at 3.
Right.
Okay. What about the Zoom witness?
Judge.
Not an issue?
No.
Okay. Anything else you want to talk about?
Yes, so we intend to enter.
Oh, we have to talk about S4. That was the other thing. So the 911 call, if you want to, you may be backing off it, but it's not in evidence yet, and so no one's heard it.
Yes, so Judge, we would still ask to play it. It's a 911 call that we filed a notice pre-trial that we were going to enter it as hearsay. It was not opposed. And so it's our understanding that it doesn't need foundation because it's self-authenticating and it could just be played even without a witness foundation.
So your December 2 notice of intent to introduce hearsay evidence covered not just the CAD reports, Exhibit A and Exhibit B. Oh, I see. It's a little subtle, but the business record certification from Ms. Wilson is for CAD report and call.
Yes, sir.
And she did that for
Not
both.
intend to slip in anything or to.
I'm not saying, it didn't jump out at me because I was looking at the document saying, oh, here are your business records. It's the CAD reports. But the actual certification from Ms. Wilson is CAD report and call, CAD report and call. One relates to the call from Mr. Duffy and the other relates to the call from Mr. Christopher.
Yes.
So I see that. So given that, Ms. Wood, tell me why you think that's not sufficient for those business records that Roswell PD keeps in the ordinary course of its business to be admitted, and if admitted, published.
It is, Your Honor. I reviewed it after we had that discussion. I pulled it up in Odyssey and saw what you just described and that
Okay.
we withdraw our foundation objection, but we did want, there's some character stuff in this particular video that we would like muted, and it involves Mr. Christopher's criminal history and stuff that's just not admissible. And so we are going to get those timestamps to the state.
Okay, and you said video. Right now, I'm talking about what's just a 911 call. In the 911 call, there's a discussion of this.
I'm sorry, I was talking about this witness. I jumped ahead without connecting them.
That's okay. So first, S4, and we'll get it on the record, will be admitted and you can publish it. That's the 911 call. Is there body cam footage from Officer Bath you want to use?
Yes, Judge.
Okay. Do you agree that there are parts of the exchange that Officer Bath or his FTO had with Mr. Christopher that ought to be muted or not played for the jury?
Judge, I believe the statement was that it was character evidence. I don't believe it's character evidence because we're not admitting it to show conformity with any type of behavior, certainly not one that's at issue here. He just makes a general statement that.
Who's he?
The defendant, Mr. Christopher, makes the general statement in the body cam that, the officer should know him because, he's been in a lot of trouble and had his run-ins with police. And he's also making statements about the police not always being fair and good guys. And so in my opinion, if we're looking at prejudice, like it probably cuts both ways. But if we're looking at
How's it relevant? It's good to know. It helps me analyze it. It's something Mr. Christopher said. So it's not from the way Ms. Feely put it, I thought that the officer was going to say, well, I just ran your name and we've arrested you 10 times before. So you should know what's coming, something like that. And I could see why there'd be an objection to that. The fact that Roswell police had arrested Mr. Christopher 10 times before, you'd have to help me understand how that's relevant. But that's not the situation. It's something that Mr. Christopher brings up in the context, I guess, of a back and forth with the officer or officers.
Yes.
Okay. And it is as generic as you all should know me because, or does he say you should know me because you arrested me for rape and you arrested me for armed robbery?
He does not name a specific crime.
Okay.
Or a specific time.
And does he say that in response to the officers in some way challenging him? Like, well, you don't know how you've never been in trouble before. It's more sua sponte from him.
It is, Judge.
Okay.
It comes out of nowhere almost.
Okay. So Ms. Feely, tell me, just because your client says it doesn't mean it's relevant. It's not hearsay, and that's not what you said. So it doesn't make it relevant, but it wasn't something that it seems like the officers either brought up or were seeking to get out of him. He brought it up. So it sounds like it's prejudicial. Is it sort of a 403 that you're traveling under? It shouldn't come in because the prejudice substantially outweighs the probative value?
Well, first, in our opinion, we don't even get there because it's not relevant and it shouldn't come in.
Okay.
But if we do get there, then yes, there's no probative value in it for this particular case. And the prejudicial effect is a criminal history is extremely prejudicial.
Sure.
So, and even though it's him saying it, it's being used now against him.
Right.
So
how's it relevant, Mr. Hand? I'm analogizing it to, at some point, Mr. Christopher's arrested in this case. And if he had in his pocket a gun when he was arrested, the defense might seek to suppress that because suppress is the wrong term. Exclude it from the jury hearing it because Mr. Christopher having a gun doesn't have anything to do with the hit and run. If it had been a hit and shoot and then they had a firearm, there'd be a connection there. So how is it relevant to proving what you need to prove that Mr. Christopher said to the officers, you should know me, I've gotten in trouble before? It may also be perfectly appropriate for you to say, and I don't think that you're not going to play when Mr. Christopher is saying the officers have been bad, they're unfair, they lie, cheat, and steal. I don't know how that's relevant either. And so maybe you don't want that in, and you'd have a similar objection if the defense tried to play it. I just like whatever you play to be as on point as possible.
Yes, Judge. Judge, I do think it's relevant. I think that a big part of this case will end up being credibility.
Mm-hmm.
And a part of that credibility is the observation of the defendant in the body cam, whether he's swaying from side to side, whether he seems nervous, what is he saying to officers to deflect from certain questions and statements? Is him saying, I've been in a lot of trouble and the department, isn't fair to, Black men or something along those lines? Is that a point of, just trying to pretty much get the officers to kind of like back off of the type of line of questioning that they have? I think that contributes to the holistic picture of whether he's believed or not. And so that's why I think it's relevant.
Okay. Ms. Feely, was there any other area of the body cam video that you were concerned about?
So that's one reason that we didn't think we would have to go this far, because it's a simple fix. We're just asking that it be muted for the timestamps that Ms. Wood has prepared.
Sure. Is that the one I didn't ask my question well then. Is that the one segment of the video that has raised concern?
Yes.
Just that, they're not, okay. Can we jump to it so I can listen to it?
Yes, Judge. Okay.
Thanks.
You said 16 to 1820?
Yeah.
Sorry, you have to stare at yourself like that. Rough.
I've been with her most of the time. I don't even know. But like I say, I just let my phone job. I got another car. You feel me? I got another
What's
car.
your other car?
Where is it?
No, what is it?
It's a red Toyota Solara.
Okay, that's what I thought. I thought you had a red car. I saw you.
15,000. Y'all
One
know
night
my-
I saw you quit. I saw you quit your
Yeah,
a red car.
yeah, you know my car. I just got this about a month ago, so y'all know my other car. I've been pulled over by y'all too many times, man. You feel me? So, you know, I've been out of. I ain't even been in no trouble for years, man. Like I said, I'm disabled, sir. I'm on a fixed income, man. You know what I'm saying? That's why I ride. Her car get better on gas. You feel me?
That was it?
But like I said, I just need to ask you for. I ain't know. You know what I'm saying? I didn't.
It seems to be stalling, Judge. I'm not sure what.
So after this, there's a discussion about my client's opinion of the Roswell Police Department, and they had this discussion about it as it pertains to my client's interactions with them in the past.
Okay.
But
So
that
he
was-
sort of did a foreshadowing here. Like, you guys stopped me a bunch of times. I've been in trouble for a while. That's not the extent. There's more.
That's the main part, Judge, but then they continue on with the back and forth.
How long is the video?
32 minutes.
About 30 minutes, Judge.
And you plan on playing the whole thing?
Yes, because this
This
interaction is the majority of the interaction. I have another body camera, but it's much shorter, and so this one is the majority of what happens here.
Okay.
I saw you quit your
Yeah,
red car.
yeah, you know my car. I just got this about a month ago, so y'all know my other car. I've been pulled over by y'all too many times, man. You feel me? So, you know, I've been out of. I ain't even been in no trouble for years, man. Like I said, I'm disabled, sir. I'm on a fixed income, man. You know what I'm saying? That's why I ride. Her car get better on gas. You feel me? But like I said, I just need to ask you for. I ain't know. You know what I'm saying? I didn't know.
We have it pulled up too. I don't know if ours will be any better. We watched it just fine just during the break.
Okay. This part, I'm going to allow you to play. What I've heard so far, I overrule the objection and find that it is relevant and that its probative value is not substantially outweighed by undue prejudice. I don't know what is said beyond that. So I can't rule on it.
We would just want to put on the record then that even if he were to testify, we would then litigate which, if any, of his convictions could be mentioned in front of the jury. So this is much different than that, but this is still, we would argue, not relevant to anything in this case and far more prejudicial than probative of anything.
Understood. I think given the language that was used and whatnot, that it doesn't its admission doesn't violate 403. So I'll allow that part in. What I take from your summation, Ms. Feely, is that whatever language follows, if technology allows us to hear it, is less problematic. And so given my ruling on this, you think it would be a similar ruling for the remainder, or you disagree?
I think the rest is worse.
Is worse.
Yes.
Okay, well, I'm not ruling on the rest. I haven't heard it.
Here it is. I'm sorry. I also have it on a USB drive, which may play much better than CD. Okay.
Yeah. Saying, you know what I'm saying? That's why I ride. Her car get better on gas. You feel me? But like I said, I just need to ask you before. I ain't know. You know what I'm saying? I didn't know it was. You know what I mean? I didn't know it was all this. You know, when I see police like this, because I've been in trouble with Roswell police so much in my life. I got PTSD. You feel me? So when I see 3 officers for an incident with
2 of them are in one car, man.
yeah, but you know, shit, when I see a lot of y'all, man.
I'm a supervisor, so I go check
Came
out guys
a long
and
way.
make
You
sure,
been here for a minute.
what they're doing. I've been around for a while.
Right. And then you gonna make sure shit's straight. Ain't no bullshit going on. You know what I'm saying? Because Roswell police for a long time had a lot of bad apples in the bunch. Man.
I don't know if I agree with that 100%.
You know what I'm saying? But we done seen it. It's been come on, flipping a coin.
They don't work here anymore.
Yeah, that's what I'm saying. It was a couple bad apples. You know what I'm saying? And then I've been here my whole life, so you know what I'm saying. That's just my opinion. You know what I'm saying? That's all I'm saying. And it's something that's done treated me with respect throughout my whole life, and I appreciate that. You know what I'm saying? So, you know, I would say
98% of the department is professional and
now.
Good. There's been a couple throughout the years. Sure, that's every job, every profession.
Right.
But I wouldn't say the way that you phrase it with a lot of bad apples. That's what I would disagree with.
Right.
We've had our share just like anybody else has, but I wouldn't say a lot.
Gotcha.
Right. I think that you get pretty good as a department. If you consider statistical.
Right. Somebody in
that person?
Is that it, or is there more? Okay. All right. I've heard it all. Ms. Feely, why don't you finalize your objection to that segment coming in?
Relevance, more prejudicial than probative. And I want to make sure, if I understand the state's argument correctly, they're wanting to use it to hurt his credibility. I think they said that verbatim. And that is the definition of improper character evidence coming in. So that is not a relevant reason for getting this evidence in.
Okay. Mr. Hand?
Judge, we did not say to hurt his credibility. We said credibility is an issue, so anything relevant to it, we believe, should be admitted.
Okay. I think it will make for a cleaner presentation and trial if we exclude this segment, now that I heard that second part of it as well. So it sounds like both sides know that window. I'll explain to the jury that there's one part, I don't know if you're going to pause it or mute it or do whatever, and don't panic if they hear a little bit of the beginning of it. But let's just mute out this segment, or you seem pretty handy at jumping, so you may be able to jump through most of it. Let's skip however you choose to do it, whatever is technically easiest for you, this segment. But let's get on the record what those timestamps are.
Judge, I believe it's the 16-minute mark through the 18:20 mark.
Do you agree with that? I don't mean to exclude more than.
Was it just flat 16?
Oh,
I thought it was.
Let's go look at the truth.
16.
You just started at 16.
Oh, okay. 16, 18,
16
20.
through 18.
I think that, well.
Do you have?
It might be maybe less than that.
Everything was intact. No, sir, it wasn't.
No damage at all.
It was no damage at all, sir.
When was the last time you drove it besides today?
I've been with her most of the time. I don't even remember. Like I say, I just let my phone drive. I got another car.
Okay. So here, I think, Judge, I'd be comfortable.
You can play more. I mean, you keep going. I'll let you know when you need to stop.
Where is it?
No, what is
it's a red Toyota Subaru.
Okay, that's what I thought. I thought you had a red car. I saw you.
2000. Y'all
One
know
night I
that.
saw you quick. I saw you quick.
Yeah.
Can you pause for a sec?
A fire emergency has been reported in the building. While this report is being verified, please leave the building. May I have your attention, please? A fire emergency has been reported in the building. While this report is being verified, please leave the building.
Let them know. Can they stay put? We're good? Okay.
May I have
This
your
only
attention,
happens during
please?
trials.
A fire emergency has been reported in the building. While this report is being verified, please leave the building. May I have your attention, please? A fire emergency.
They were leaving already?
in the building.
I bet.
While this
We're
report
done.
is being verified, please leave the building. May I have your attention, please? A fire emergency has been reported in the building. While this report is being verified, please leave the building. May I have your attention, please? A fire emergency has been reported in the building. While this report is being verified, please leave the building. May I have your attention, please? A fire emergency has been reported in the building. While this report is being verified, please leave the building. May I have your attention, please? A fire emergency has been reported in the building. While this report is being verified, please leave the building. May I have your attention, please? A fire emergency has been reported in the building. While this report is being verified, please leave the building. May I have your attention, please? A fire emergency has been reported in the building. While this report is being verified, please leave the building. May I have your attention, please? A fire emergency has been reported in the building. While this report is being verified, please leave the building. May I have your attention, please? A fire emergency has been reported in the building. While this report is being verified, please leave the building. May I have your attention, please? A fire emergency has been reported in the building. While this report is being verified, please leave the building. May I have your attention, please? A fire emergency has been reported in the building. While this report is being verified, please leave the building. May I have your attention, please? A fire emergency has been reported in the building. While this report is being verified, please leave the building. May I have your attention, please? A fire emergency has been reported in the building. While this report is being verified, please leave the building.
Yeah, but how long does it take for this to turn up? Don't you have some button?
May I have your attention, please? A fire emergency has been reported in the building. While this report is being verified, please leave the building. May I have your attention, please? A fire emergency has been reported in the building. While this report is being verified, please leave the building.
Attention in the building, attention in the building. This is the Fulton County Sheriff Office. Please stand down. Attention in the building, attention in the building. This is the Fulton County Sheriff Office. Please stand down. Everything is code 10 at this time. Stand by for further.
Code 10 is good.
May I have your attention?
It's not active
A fire
shooter.
emergency has been reported in the building. While this report is being verified, please leave the building.
One of the jurors asked was you still here.
That's funny.
Oh, my goodness.
I took off right away. Oh, it's sounding quieter. All right, please keep playing.
I don't know what it did, but.
The car, I just got this about a month ago, so y'all know my other car. I've been pulled over by y'all too many times, man.
All right, so just before that, I just got my new car, whatever it was, whatever that timestamp was, stop there.
6:20.
6:20. No, 16.
16:20.
I don't know where you're seeing this 16, but
Yeah, you know my car.
Just at the bottom. So 16:18.
okay. And then you know where to start it back up again.
Yes, Judge.
Okay.
Judge, I do have one more request. I know it's fitting.
It is.
I'm sorry. Judge, there is a part of this video where a witness makes a statement. So there's a witness that we have not heard of yet, who is in a parked car in this lot. He gives testimony that when he arrived there at 6 o'clock that day, there was no other car in that lot, including the car belonging to Mr. Landon. That individual is in the wind, Judge. We talked to him, he confirmed what we suspected was on body cam or knew what was on the body cam, and now he's just vanished. The worry of the state is if his testimony comes in through the body cam, then in closing arguments, the defense may say, well, why didn't the state go find them? Or why isn't that person here when we've had an investigator go a very extra length to find this person, including staking outside relative homes.
So what is your request?
My request is to.
Is this Melvin Wheeler?
Yes.
Okay.
My request is to redact that portion of the video as well.
Okay. I don't know why there'd be an objection to that. I thought you were going to try to convince me that it should be played, even though he can't come to court. Because it sounds like it's, but no one's objecting to that not being played.
Withdrawn, Judge.
But now we're going to move to redact it.
Yeah. Now that you've flagged that,
No,
why would
we
you be
flagged
able
it
to
too.
play it without, he's not available? is an out-of-court statement being offered to prove the truth of the matter asserted that Mr. Christopher's car was not in the parking lot at 6 that morning or evening, whenever it was. So it's hearsay unless you've got an exception for it. It could come in after Mr. Wheeler testified if he were impeached in the way that we may hear a lot from Ms. Newborn's cousin. But how does Mr. Wheeler's out-of-court statement to law enforcement? So it is, it's covered by all the confrontation clause concerns that are out there.
Well, Judge, I would say that the state has gone to extraordinary length to find this individual and request that he be considered unavailable, such that his statement be allowed in.
Okay.
And just as a
Hold
point of
on.
clarification, okay, sorry. I think we're talking about separate videos is the thing. I think we're talking about separate videos, which is why, because we were going to move to redact, but we didn't do it on this one because I don't think this is the video with Mr. Wheeler in it.
I don't know which video Mr. Wheeler is on.
Judge, there are statements about him in this video.
Who makes statements about him on this video?
And an officer, Judge.
Yes.
So there's
So-
statements, so.
Right, but there's an officer who says in effect, hey, I just talked to some guy who says there was no car in this parking lot a while ago.
This is what happens, Judge.
Okay, got it. That would also be hearsay. So let's not play that part. I don't know where that is in there, but let's not play that part. And whichever video has the interview of Mr. Wheeler, let's not include Mr. Wheeler's interview. I trust you when you say he's not available, but I don't think that unavailability is the kind that allows it to come in. If you had evidence that Mr. Christopher was helping Mr. Wheeler be unavailable, then I'd let you play it 10 times.
Okay, Judge. Is there a concern that the jury will see me skipping around and?
No, because I'm going to tell them that there are certain parts of the interview with Mr. Christopher that aren't relevant. And so that I've asked you as the video operator to skip over those.
Okay. Will do, Judge.
So to recap, states 4, you need to move to admit, but it will be admitted. I don't know what exhibit number Officer Bath's body cam footage will be, but assuming you lay the right foundation for it, you can play it, and there will be 2 parts that you sort of self-redact. One is Mr. Christopher letting the world know he's been in trouble a lot, and the other is whatever some officer says on this recording, meaning Officer Bath's recording, about having interacted with Mr. Wheeler and what Mr. Wheeler had to say.
Yes, Judge. And just for your knowledge, it's in 2 locations. So
Okay.
I just don't want you to think I'm skipping something else that's random and.
Nope. Anything else concerning Officer Bath's testimony?
No, Judge.
Ms. Feely, anything else, or Ms. Wood in connection with Officer Bath?
Not with Officer Bath.
Okay, let's bring the jury in, please.
That's, are you calling Fortunato or not? Judge, there might be one other issue.
Okay, we'll deal with it when it comes up.
Thank you, Judge.
Yep.
He's having connection issues. We gotta put some stuff on the record then.
Is going back into the fire hose. So I hope.
All rise, adjourned.
Thank you, Deputy Gordon. Everyone can be seated. Well, I thought we had put the fire out. I think these lights will turn off in just. Welcome to Fulton County. It was a false alarm, and Deputy Gordon got to you as soon as he could. He had to get the clear on that. We were working through something that involved, can you take the share screen off now?
Yes, sir.
The video you see up on the screen, which you may see later. And then we had to pause because we couldn't hear the video because the fire alarm was going off. We've completed that, made you get back from lunch a little early. Sorry about that. We meant to be ready to go at 1:30. And then what was going to take about 10 minutes took longer because they're trying to figure out how to operate the fire alarm system. When we paused, Officer Bath was partway through his testimony. He remains under oath and do you think they know they're doing this? They do. Okay. Pardon? Is it going to cycle through all the noises it can make? Okay. Can you radio them not to touch it anymore? Because it's off now. All right. Officer Bath remains under oath, and we are in the midst of his direct examination. Mr. Hand.
Yes, Judge. Judge, the statement of minutes request to admit Estates 4, the 911 call. That was related to case number 2012-000435.
The situation Officer Bath has been talking about responding to the criminal damage to property, hit and run, whatever it was.
Yes, sir.
Okay. Any objection to the admission and publication of States 4?
No, you're.
It's admitted and you can play it.
Thank you, Judge.
Roswell Police, what's the location of the incident?
I'm on Atlanta Street, sir. Well, actually, I guess it wouldn't be Atlanta Street. I'm behind the Chevron, like kind of like by Pleasant Hill Baptist Church in the parking lot right here.
Okay. All right. And what's that location? One more time for verification.
I'm by Pleasant Hill Church. I'm not sure what street. Pleasant Hill Street, I believe.
All right. And what's the telephone number you're calling me from?
678-254-8292.
And that telephone number one more time for verification.
678-254-8292.
Okay. Your name?
Landon Christopher.
Okay. Okay, Landon. Tell me exactly what happened.
I'm with a friend of mine. This morning, we've been hanging out all day. I left my car parked over here. I come back and there's I'd call it significant damage just because I just got this car and it looks like maybe somebody might have sideswiped it or something. My mirror's gone. Not sure what happened.
Okay. All right. Let's see. Okay, here we go. All right. What's the okay. Are you at the location now?
Yes, sir, I am.
Okay. Okay, I'm just updating my call so the officers know exactly what they're coming to. Okay. Okay, when did this happen? Landon, when did this happen?
Today. I parked here around, I'd say 10:30ish.
Okay.
And just now getting back to the scene.
Okay. All right. And is the you might know the answer to this question. You might not. It's okay to not know. Is the suspect in the area?
That I'm not sure. I don't. Like I said, I've been gone since like 10:30 a.m. this morning, and it's approximately 9 o'clock right now. So I'm not really sure what time this happened.
Okay. Do not disturb anything at the scene. An officer will be dispatched as soon as possible.
Okay.
All right. And they're going to make contact. They're going to make contact with you. And I need to get your contact information. Just so the officer knows who they're pulling out with. Can you describe yourself to me?
I'm about 6'2". I got on the blue hoodie and black pants.
Okay.
And I understand this probably wouldn't be like considered an emergency, but like will it probably be a long time before you can get an officer out here?
Actually, the officer is close by, and they're going to be pulling out with you very soon. Where exactly is the vehicle parked currently?
It's in the church park. It's in the church parking lot, behind the store. Not in the actual church, but the church parking lot across from the church.
Okay.
Behind the store.
Right. Not across from the church. All right. And can I get a description of that vehicle?
It's a 2006 Toyota Highlander, a tan, I'd say tan color.
Okay. All right. Very good. Okay. What's that? Do you have? Give me the plate. The plate number.
RSQ. That's going to be RSQ 8855.
All right, pretty good. I appreciate that. That'll help the officer when they get there. All right, I have your information. You're with the vehicle now. Is that correct?
Yes, sir. I'm right outside of the vehicle. Well, I'm in my friend's car.
Okay.
In and outside. Well, we're right here next to the vehicle. Yes, sir.
All right, very good. And what type of vehicle are you standing by in? What type of car is your friend?
A white Kia.
Okay.
Forte.
Okay. Okay. Okay, the officer's on the way, and they have been dispatched, and they will be pulling out with you shortly. I appreciate your time.
All right, thank you, sir.
No problem.
Judge, also at this time, the state requests you admit the CAD report associated with this 911 call, which was filed at the same time as the 911 call.
That's Exhibit A.
That's Exhibit.
I guess it's Exhibit B.
B.
Okay. Any objection, Ms. Wood, to the CAD report that's associated with this 911 call being emitted?
No objection.
Okay, that would be States 5.
Yes, sir.
Okay.
Recognize as I'm approaching Officer Bath, but Officer Bath, you know what a CAD report is?
Yes, this is, I mean, what we're receiving when we're receiving the call for
Okay.
service.
And what type of information is typically on a CAD report?
Typically, the first thing we're going to find out is what the nature of the call is, who may be calling, the threat that could be towards the person at the time, just to let us know how we're going to respond. There's going to be a very short narrative from the person calling stating what they know or what they believe has happened.
Okay, and you mean a 911 call?
Exactly.
And are there any specific times recorded for when that call is made in the actual CAD report?
I don't understand your question.
Yeah, sorry. Let me frame it better for you. Do CAD reports include what time the caller made the time?
Yes.
Can you tell based on that document what time the 911 call that we just heard was made?
Received was 2100 hours, 9 o'clock.
Okay, and does it have a date as well?
It does. It's 12/13.
Which would be December 13th of?
I'm sorry, 2020.
Officer Bath, did you have your body-worn camera on that day?
I did.
And were you able to record the events that occurred that day as well?
I was.
Using your body cam?
I was.
Okay. Judge, the state would request at this time to admit as states 6, the body-worn camera footage of Officer Bath.
Any objection, subject to discussions we've had outside the presence of the jury, to the admission of state 6? It's admitted?
Judge, and I will adhere to that.
All right, so.
Can you pause it for a second, please? I didn't know you were about to publish it. Ladies and gentlemen, because of discussions we've had outside your presence, I've made some rulings that require Mr. Hand to either mute or just skip over, I think it's 3 segments in this video. So I don't want you to think that Mr. Hand doesn't want you to see something. Why is he making it chop? It has not been edited, so it will be manually edited. Mr. Hand knows at what point he either needs to turn the volume to 0 or stop it and jump to the next piece. But I think that will happen 3 times, just because there's something discussed among the people who are on the screen that isn't relevant or is for whatever reason not admissible in the course of these proceedings, at least not at this time.
I'm all right, sir. How you do?
I'm doing good, man.
All right, so is this the vehicle?
Yes, sir.
That's our hit and run.
Hold up right now.
Whose vehicle is this, sir?
Sir?
Whose vehicle?
Mine.
Can you pause for a second?
When was the last time you operated it?
Who's doing the talking, you or?
I'm doing the talking at this time, Your Honor.
Okay, and did you almost immediately say, that's our hit and run?
I'd have to hear that replayed.
Can you replay that, please?
You can go back a few seconds.
How y'all doing, man?
I'm all right, sir. How you do?
I'm doing good, man.
All right, so is this the vehicle?
Yes, sir.
That's our hit and run.
So pause. Who said that? You or the other person?
I don't remember saying those words, Your Honor.
Whose voice was it saying those words?
It did not sound like mine with my way of speaking, Southern slang, if you will.
Okay, I wasn't attacking the tone.
We can replay it again if I think it's my words.
I'm less concerned about who said it. It's one of the two officers. It's you or your colleague.
Okay, if I may listen to it one more time.
Okay.
I'm all right, sir. How do you?
I'm doing good, man.
All right, so is this the vehicle?
Yes, sir.
That's our hit and run. It sounds like my voice.
Okay. And what did you mean when you said that?
The previous day is we did have an incident where an incident that took place pretty close to this area. A person was walking on the side of the road and they were struck by the vehicle. The person that was struck by the vehicle or another witness that saw the person struck by the vehicle.
I want you to talk about what other witnesses said, though.
Okay.
You were associating this vehicle with that situation.
A tan colored Toyota SUV saw striking a person on the side of Dogwood Road, I believe.
Okay. Thank you.
And officer, you're instructed to be on the lookout. Is that true for this type of vehicle?
Yes, sir.
Okay, so it wasn't that you personally observed this or had personal knowledge of this?
No.
Okay, just, is it routine for officers to share information to be on the lookout for certain vehicles or individuals?
All the time.
Okay. Were you told about any specific type of damage to be on the lookout for?
They said it would be front end damage. They said at the time what would be missing from the vehicle by evidence that was gathered.
Okay.
So,
And what those items were?
it was going to be like pieces of the front bumper to above the above the wheel, that body area, and a mirror.
Okay.
Belonging to the passenger side of the vehicle.
Okay. So if you had observed that, then it would make sense for you to make the connection between the lookout and what you observed.
Yes.
Now, I know the video is a bit dark, but in person, there might be more light for you to see that. Okay.
Whose vehicle is this, sir?
Sir?
Whose vehicle?
Mine.
That is yours?
Yeah.
When was the last time you operated it?
It's been probably like this morning.
This morning?
Yeah.
Okay. The time before that? Have you had it this entire time and you just dropped it off this morning?
Yeah. Okay. I was driving this morning, came and dropped it off.
So who drove it since then? Who drove it since then?
I don't know.
So you don't know you don't know who drove it?
No, I'm the one that drove
Okay,
it.
well-
But I parked there this morning. I just seen this damage this morning.
You saw it this morning.
Yes, sir.
And who had it before then? Who had it before then?
I don't. What do you mean?
Well, this didn't happen here.
This happened. This happened here. I'm sure.
Okay, well, where's the mirror?
I'm not sure.
Where's the pieces of the car?
I'm not sure.
This didn't happen here.
This happened here. Sure.
Good try to be patient. Just gonna get this information about when was last time driven, who had it last, that type of thing.
Okay. You go by Chris?
Sir.
You just go by Chris? You prefer Christopher?
Landon.
Lander?
Yeah.
Landon? Okay. All right, Landon. So you're saying you dropped it off here this morning?
Yes, sir. I was hanging out with my friend right here all day.
And saying there was no damage this morning?
No, sir.
Okay, and the days before, you've had control of this vehicle the entire time? All the days leading up to today, you've had possession of the vehicle?
I let a couple friends drive it. I mean, I be letting my friends drive my car sometimes. Cause I got another vehicle.
Okay. But the vehicle has been in your possession?
Like I said, I let my friends drive sometimes.
Okay.
Hello?
Who was the last friend that you let borrow your vehicle?
I don't even remember now.
Okay, when was the last time you think you let your friend borrow a vehicle?
I'm not sure. I let my friends use it a lot. You know what I'm saying?
Okay.
Please leave your message.
In the past week, you think? Any? Or you?
Yeah, of course. I've had the vehicle about a month, so yeah, the whole time that I've had it, I let my friends drive it.
Please leave your message.
What's a phone number I can reach you at?
678-254-8292.
Is your address on here correct where you're living now?
Yes, sir.
Okay, everything's okay.
Just wanted to get it for my insurance, man.
I understand. What they will want to know probably is, who was driving, who all has been driving it.
Right.
That's what I'm just trying to get to.
Right.
I mean,
like I said,
you just don't let anybody walk in and say, "Hey, I need to borrow your car," and you let them take it.
oh yeah, like my close friends though.
It's got to be a close friend that takes it, right?
Like homeboys and stuff. You know what I'm saying?
Right. So, who would be the last person that you would say drove this vehicle? That you let him borrow it?
I don't even remember, man.
Okay. All right. Do me a favor, hang tight. We're going to step back to the vehicle.
Okay. Come on, step back over here.
Yeah, that'd be fine.
Don't let on.
Yeah, my bad. I guess he's probably already in here. Should I put him to takedowns just to see what's happening over there?
No, it's fine. She's claiming she was with him when he dropped the car off in here this morning at 10:30.
Okay.
So I didn't get into it too much with her, but there's someone sleeping in that car next to the
This would be one of the pauses?
Yes, Judge.
Okay.
prom already knew who he was.
Okay.
So I'll go ahead and run this tag. CMJ 2121.
There's a message for you.
That's right.
Okay. Valid. Insurance valid. Her license say Cumming, Georgia.
get his phone number?
I did.
What do I need to do at this point?
Just hang tight.
Everything all good?
Yeah, everything's fine.
Okay.
You're not going to lose whatever's on that chain right there, right?
Oh, no, it's just my keys.
Okay.
Step over here.
What's going on, man?
It's just an investigation. He's talking to her about a few things, that's all.
What type of investigation?
I'm not over there, I'm not sure.
How you doing, officer? You the sergeant?
Yes.
What's going on, man?
I'm like, you come in, what's up?
Huh?
You come in, what's
I'm
up?
just calling. I'm just calling because when I came back from dropping my car, I noticed the damage, and I'm calling for my insurance purposes. I've only had the car a month. So.
How long has the car been here?
Since this morning.
This morning?
Yeah.
Where do you usually park it at?
I park it here all the time.
Okay. Where you stay at? Where you stay at?
On 725 down room.
You stay at that one, but you park it here?
Yeah, my mom lives down here. I'll be over here with my mom. Too.
Okay.
My mom Debbie's cool. Y'all probably know
I
her.
know you.
You know what I'm saying? So I'll be over here a lot. I'm from here. I've been here 32 years. But I be staying with my grandma. You know what I'm saying? I got another vehicle that I be driving. You know what I'm saying? Like I told the officer, I be laying.
Judge, I believe it's another.
Yep. This is number 2.
That came a bit early, earlier than I had notated time-wise. And I don't want to play this in its theater.
Okay. We spent some time identifying the time markers, so it shouldn't change. It's a static video, but however you want to move to the next segment.
Feels sufficiently enough, Judge, that.
With respect throughout my whole.
You don't. But you don't know her?
I didn't know nobody was there.
Judge Steve.
So you're saying a car pulled out and hit your car?
I'm not sure what happened, sir.
I know exactly what happened, because I know what this car is from 2 nights ago.
I don't know. I don't know what you're talking about, sir.
That's fine.
I'm just telling you what I saw, sir.
Whatever.
What is he talking about?
I'm not sure just yet. I wasn't on duty that night.
2 nights ago. I was at home with my girl 2 nights ago.
Which one? Her?
Huh?
You were at home with her?
Nah, that's my friend. I'm a player, man. I'm a player, man. Do I need to call my lawyer, man? Am I being detained?
I don't see a reason for you to have to call a lawyer.
I don't know. I ain't been in trouble in a minute, man. I just like to be ahead of things. I learned to try to jump ahead of the ball if it's gonna be that. You know what I'm saying? Y'all just, folks can just sleep in the parking lot right there.
Please leave your message.
Temperature dropping, huh? I done had surgery on my back right here, sir. Man, and like I said, I'm disabled, man. I got all my paperwork, man. But I can't be standing too long. Is it cool if I sit back down in the car?
Not in the car right now. If you want to lean against the back of the car right there.
I ain't trying.
I mean, you can lean on one of those bars. It'll take some weight off you.
I'm trying to lean. I'm trying to sit down, man. I'm not in the back of no car.
Let's move back a little bit.
What up, boy?
One more.
All right.
So it's something you're saying that happened 2 days ago. Sarge, can I talk to you, man?
Yeah.
Can I talk to you? Sure. This man talking about I'm involved in something 2 nights ago. I don't know nothing about it. Nothing that happened 2 nights ago, man. And my car, as far as I know, ain't been involved in nothing from no 2 nights ago. So how can y'all
What are you gonna do with her?
Huh?
What are we gonna do with her?
We're probably gonna cover this problem.
Both of them?
She's lying, says she doesn't know anything. I don't know if you heard the guy that was sleeping in the car, said he pulled in at 6 o'clock. The car was
They could have came anything. I don't know, sir. I don't know. How is that inconsistent? I told you.
You think anybody would come over here and clean up the police?
This is a church. If somebody got a park there, this church parking lot is full every Sunday morning. If somebody got a park there and it's glass and debris, yes, sir, I believe somebody would.
But you know the church, did you know that this church currently is not having services going on?
I don't know what they
So
do.
nobody was parking in the parking lot?
I seen cars when I parked here. I seen cars when I parked here.
Well, we're going to impound the call for our investigation.
But how can y'all just come up and say that my car was involved? How can you say that?
I gave you the facts and the circumstances.
What are the facts?
We have the mirror for your car.
You don't have the mirror to
Yes,
my
I
car.
do.
You don't have the mirror to my car.
Well, we'll see about that.
So at this point, am I
And
under?
I have the pieces of your headlight. You're not under arrest.
Am I under arrest?
Nope. Well, we're getting there.
What does that mean?
We're investigating a hit and run where a pedestrian was hit by a vehicle that 100% matches your vehicle. 100% matches the damage in it from Friday night, Saturday night. Okay. The story that you're telling me, I frankly, to be honest with you, I don't believe it.
Okay.
Okay. Talking to your friend over here, I don't believe her version of the events either. Right? How did she know to pick you up this morning?
We talked.
On
through the phone. FaceTime.
Did you call her? Did you
Yeah.
text her?
Yeah, we FaceTime.
You FaceTime? Would you show me that in your call log that you FaceTime with this morning?
I mean, I ain't gotta. Do I have to show you that?
I'm asking if you have proof that you called her at that time this morning. Wouldn't you want to show me that?
I mean, my word ain't enough.
It's not.
Why?
Because I need proof. I look for proof.
I mean, I'm not on trial right now.
No, but
I'm not in the court of law.
Listen.
Like I said, I told you what happened, sir.
Will you listen for a second?
I told you what happened. I don't know anything else, sir.
So, if you have
At this point, I refuse. I have the right to remain silent, sir. You know what I'm saying?
So change it.
Yeah, right.
But we're still gonna impound the car.
But how can you just take my car?
I just told you.
Yeah,
Because I believe you've been hit and run. So we're towing it so that we don't lose the evidence of that vehicle.
I'm
It'll be
not.
towed to the Roswell Police Department.
So at this point, sir, if I refuse to give you my keys, if I refuse to
we're still
give,
gonna tow whether you give me your keys or not.
okay, that's cool. That's fine. Am I free to go? Can I get the incident report?
Yeah,
The number.
We'll give you the report number for today.
Okay.
Right? But also let me caution you, if and when we prove that this vehicle was used on hit and run, the statements you made today are the false statements to the police, which is
I didn't make no false. I didn't make no false statement.
You didn't? You didn't tell us that you parked the car here with no damage to it. When you came back, it was damaged. You're not falsely reporting that your vehicle was hit and run.
I didn't give you.
You didn't say that to me. You said that to me. You said that to this
I didn't give you any false information.
That's a false statement.
I didn't give you any false. I didn't give you.
You're filing a false report.
No, I'm not, sir.
Saying that your vehicle was damaged in this parking lot. You're going down a path here, man. You're going to get yourself in more trouble than if you just say, look, yeah, I got in an accident.
No, I didn't give you nothing, man.
Okay. When I prove that this is the vehicle that was using it, which is your vehicle, and I prove that your statements today is false, then we will also charge you with the false statements to police. Okay? I'm just being honest with you, and I'm being straight up with you. I'm giving you a chance to at least show the proof that you called your girl this morning to come pick you up.
I saw that to my lawyer, man.
Because you don't have it.
I saw you. I saw
you
that.
don't have it. And she
I saw you. I saw that.
I've already tried to do it.
I saw it to my lawyer, man.
And somebody who's innocent has got nothing to hide.
I ain't hiding nothing.
More
I
than
told
willing
you.
to say, yeah, here's
You calling me a liar? You said what I said. What I said happened. Didn't
I
happen.
don't believe what you said.
That's fine. That's fine. But what I'm saying is what happened, sir.
Well, I don't believe it. And the evidence says otherwise. And now we'll continue to follow up on that. And when we're able to prove it and have probable cause for that, then we'll get on that. Okay? Do you want your accident? You want your case on?
Yeah. Can I get that
for your report of your accident?
I'll call and get it. Okay. Appreciate that, y'all.
You want your ID?
Do you want your ID back?
Oh yeah. I need
it. You need it for anything?
Hey, she said y'all got her ID too.
Yeah, we're gonna give it to you. You take it back to you.
Appreciate that, man. Now we go. I get something out my car.
Nope.
Well, I can't get nothing out my car.
We're taking it forever.
How y'all gonna take my car for
I
evidence,
just explained
man?
that to you. I just spent 10 minutes explaining.
Come on, man. I
touch the
can't.
car,
Man, it's not my
Now,
personal.
would you like to leave your keys so that we don't have to damage
Nah,
the car
man.
when we process it?
Nah, man.
Okay, that's fine. You can't touch the car though.
That's crazy, man.
We go to 35 minutes inside evidence.
Officer Bath, that now that your body cam is a bit closer, can you clearly see the damage to the car?
I can.
And was that consistent with the damage you were told to look out for that vehicle?
It was.
Okay, thank you. Judge, that's the gist of this.
Okay.
Officer Bath, did we just watch extensive interaction between the defendant and at least 2 or 3 different officers?
Yes.
And you were listening to those conversations as well as being a part of them, right?
I can say I was listening to the conversations. What I can't speculate on what I might have heard. I mean, some things they said was they were standing away from me, talking in a different way.
Right.
And I'm actually standing with Mr. Christopher at a separate spot in some areas as well.
Gotcha. Let's focus on your conversation with Ms. Land. Mr. Christopher, when you asked him who had driven his car in the last few days or week, what response did you get?
He didn't have a name. He said, he's got some of his, I believe the word was homeboys come by sometimes, and if they need to borrow the ride, they can borrow the ride.
Did he claim that it was his vehicle?
Yes,
Okay, so you knew that much.
yes.
Did he ever make any statements to you about having the key to that vehicle?
I don't recall.
Okay, but you just knew it was his vehicle.
We had already ran the plate to the vehicle.
Okay.
Everything was coming back clean.
Okay. Oh, all right. No further questions.
Ms. Feely, questions for Officer Bath?
Briefly, thank you. So you testified you knew about this hit and run from a day or two ago?
Yes,
And Roswell Police, most of you guys who had been working around that time knew about the hit and run from that day.
yes,
And that's why you said, or the other officer, this is our hit and run, or this is the hit and run early on in the video.
that's correct.
And it was your understanding that there was an eyewitness who saw the car hit the pedestrian.
That's, like I said, that was my understanding. I was not out on that call, and I did not read the report.
That wasn't your case.
Correct.
So you wouldn't know that person's name.
No, I would not.
Thank you.
Mr. Hand, any redirect? Questions from the jurors for Officer Bath? Yep, see a couple? Deputy Gordon, if you would collect those, please. I like it. That's good. You're checking with everyone. So future reference, please write on one side of the card and do not fold, spindle, and mutilate the card after you write on it. Thank you. Counsel? Officer Bath, did Mr. Christopher appear to you during your interactions with him, your observations of him that night of the 13th? Did he appear to you to be intoxicated or under the influence of anything?
No, we did not.
Did you learn if there were any cameras, video surveillance cameras in that church parking lot?
No, I did not.
Did you or anyone with you examine the Toyota, the Highlander, that was the vehicle of interest there, that was damaged, to see if there was paint from another car on it?
No, I personally did not.
If someone from Roswell Police would have done that, would that have been, we heard a little bit about the traffic unit that investigates accidents and things like that. Would that have been a traffic unit detective who would look at that, or a first responder like you?
No, that's going to be more of an investigative role.
It'd be more like an investigator role? Okay. Could you tell from being there, as opposed to some of the footage that it was dark, if that Highlander was backed into the spot where it was parked, or if it was able to pull straight in, because it looked like there were trees behind there, but it wasn't real clear to us looking at the video?
I didn't personally see any tire marks that would let me know one way or the other in that situation.
So let me ask the question a different way. Where you found, where the Highlander was found, was it possible for that to have pulled in going forward, or was that a spot? It was nose forward. When we saw Mr. Hand stop the video and said, is that damage consistent with, we're looking head on at the Highlander. Could that Highlander have parked by driving forward into that spot? Or is that a spot where it had to back into?
Looking at the photo, it looks like a parking job where they backed into the spot.
Did you or any of the officers with you locate parts from another car around or not inside, but around the area where that Highlander was parked?
No, we did not.
Are you able to estimate, emphasis on the word estimate, the distance between that parking lot where you encountered Mr. Christopher and where you understood the hit and run incident from the night before to have been?
If I was going to estimate, I would say roughly 3 miles.
Do you know if anyone involved in the investigation into the hit and run gathered cell phone records for anyone's phone that might show where phones were the night of the hit and run?
I'm not privileged to that information.
You didn't?
I did not.
Okay. Mr. Hand, do you have any other questions for Officer Bath based on those questions?
Yes, Officer Bath, remind us again how long you had been on that job before this call?
I would say, roughly 5 to 6 months.
Okay. And so would you describe your police work in conjunction with your partner to be more limited by comparison to him?
Absolutely.
Okay. Nothing further, Judge.
Ms. Feely, any other questions for Officer Bath?
No, Your Honor, thank you.
Officer Bath, thank you for your time and staying over lunch as well. You are free to go. Your next witness.
Yes, Judge. So the state will call Officer Lewis.
Officer Lewis. Okay.
That's where. Jason Lewis, last name Lewis, Lewis.
Officer Lewis, good afternoon.
Yeah.
Can you just briefly tell the court where you're employed and how long it's been employed?
Roswell Police Department for about 3 years now.
Okay. And were you employed December 13th, 2020?
Yes, I was.
Do you remember responding to a property vandalism call on that evening?
Yes, I did.
And did you respond alone?
No, I responded with Officer Bath.
Okay. And do you remember the location or an estimate of the location where you responded to?
Yes, it was the Pleasant Hill Baptist Church in Roswell.
Okay. Was there a particular portion of the church?
I believe it's like a lower parking lot. It wasn't the main parking lot of the church. It's technically across the street from it.
Okay. And when you and the co-officer responded, around what time did you get them?
It was about after 9 p.m., 9:09 p.m.
And what did you observe once you got it?
We responded to a call about a gentleman that parked his car in the parking lot, returned to the parking lot to find the car had been damaged, possibly in a hit and run or just had damage to it. We pulled in the parking lot. There were 4 vehicles in the parking lot. First, in succession, first was the caller's car. That was Landon Christopher, I'm sorry. Landon Christopher's vehicle.
Well, sorry, before you get too far, officer, if you can focus on just the vehicles that you spoke in, that I assume you're going to say Ms. Newborn's vehicle as well.
Yeah, I was getting there.
You can just focus on her vehicle and the defendant's vehicle.
Okay.
We'll be good. So go ahead.
So yes, the vehicle in question was this Mr. Christopher's 2006 Toyota Highlander. It was backed into a space and we pulled almost directly in front of it because that was the vehicle that was being called in. And I recognized the description of the vehicle from a BOLA that was put out. A couple cars down was a white passenger car that was occupied by a female.
Okay. Do you remember the name of the person?
If I can look at my notes, Kayla Newborn.
And did you speak at all to either one of them when you were in the lot?
In passing, I spoke to Mr. Christopher, asked questions here and there, but he was primarily, Officer Bath was mainly speaking to him. So I let Officer Bath handle that part of the investigation, of the questioning. And while he did that, I looked at the vehicle, the Highlander, and then Miss Newborn.
Okay. When you looked at the Highlander, what did you observe about the Highlander?
There was damage to the front end, the front right portion, the passenger side. The headlight assembly, turn signal light was shattered, missing glass from the headlight. A portion of the bumper was missing. Damage going down the quarter panel along the side, almost like a rippling accordion effect. And the exterior passenger mirror was missing.
And did you get an opportunity to look inside the vehicle from outside?
Yes, I can look and see in through the windows.
Did you know anything noteworthy?
Nothing unusual, no.
What description did you receive to be on the lookout for, vehicle-wise, versus what you observed when you were actually, by comparison to what you observed when you were there?
The day before, every day we got a shift report from the prior shift, we get an email. And one information on that shift report was a hit and run injury accident. And the vehicle that fled the scene, it was described, I don't recall how they knew this, but it was described as not a tan, let me retract that, a 2001 to 2006 Toyota Highlander. And so when we showed up at the scene of the damage to property call, it was a Toyota Highlander with the damage to the front end there.
Okay. And was it, so you said damage to the front end, was that the description you were given of the vehicle to be looking at?
The original Bolo, I don't recall.
Okay. But
I knew it was a pedestrian that was hit. I do recall that.
Okay. But it was something about the damage that matched you to the car, or was it just that it was a Highlander?
It was a Highlander with damage and other factors that led me to believe that it was the vehicle.
Okay. And did you call anyone else to the location after arriving?
After I learned some information about the vehicle and how it was described as being damaged, I contacted my supervisor to let him know that there's a vehicle here that matched the description of the hit and run from the night before or 2 nights before.
Okay. And did your supervisor arrive on scene?
Yes, he did.
You also spoke with, you say you spoke with Ms. Newborn as well,
yes.
Right? Was that interaction or the whole interaction together recorded on your body cam?
Yes, it was.
And would it show an accurate depiction of what occurred?
Yes.
The individuals you spoke with?
Yes.
Okay. Judge, at this time, the state would request to tender into evidence. Well, one moment. Let me back up, Judge. You recognize this?
Yes, it's a DVD that you showed me earlier.
Okay. And what's on the DVD?
A copy of my body camera video from the incident.
And how do you know that particular copy?
My name is on, and I recall you showing it to me, and I initialed it.
Judge, now the statement requested in moving evidence states 7, which is provided one camera footage of Officer Lewis with the same redaction that's discussed for the previous body cam.
Okay, Ms. Feely, assuming Mr. Hand is able to manually redact on the fly, as we discussed outside the presence of the jury, any objection to the admission? Well, it's any objection to the admission.
No, conditioned on what we discussed.
Okay, so S7 is part of the record. In terms of publishing it, assuming that one redaction occurs, no objection to the publication of S7.
Yes, Your Honor.
All right, you're good to go.
Thank you.
S7 is admitted.
All right, so how y'all doing, man? I'm awesome. How you? I'm doing good. All right, so is this a vehicle? Yes, sir. That's okay, you know.
Hold up right now.
Whose vehicle is this? Sir, whose vehicle? Mine. Are these yours? Yeah. When was the last time you operated it?
The delay, Judge, I'm sorry.
Do you have a thumb drive version?
I'm playing it from the thumb drive.
Oh, okay.
How y'all doing, man? I'm awesome. How you? I'm doing good. All right, so is this a vehicle? Yes, sir. That's okay, you know.
Hold up right now.
Whose vehicle is this? Sir, whose vehicle? Mine. Are these yours? Yeah. When was the last time you operated it?
It's been probably like this morning.
Morning? Yeah. Okay. Time before that? Have you had it this entire time and you dropped it off this morning?
Yeah. I was driving this morning and came and dropped it off.
So who drove it since then?
Huh?
Who drove it since then?
I don't know.
So you don't know you don't know who drove it?
No, I'm the one who drove
Okay,
it.
well,
I parked there this morning. I just seen this damage this morning.
You just saw it this morning?
Yes, sir.
And who had it before then?
Huh?
Who had it before then?
I don't. What do you mean? Who had it?
Well, this didn't happen here.
This happened. This happened here. I'm sure.
Okay? Then where's the mirror?
I'm not sure.
Where's the pieces of the car?
I'm not sure.
This didn't happen here.
This happened here, sir.
Okay, let's try ID, please. Just going to get this information about when it was last time driven, who had it last, that type of thing.
Okay.
You might want to head over to us at Pleasant Hill Baptist Church. We're out with a beige Highlander that's missing a passenger side mirror.
Nice.
And he's claiming he parked it here this morning and it was damaged here this morning. There's no way in hell that car's messed up.
Yeah. Oh, he's with it?
Yeah.
Oh, who is it? Landon Christopher?
Yep.
Oh, that's really big guy. All right, cool.
All right.
All right.
Hey there.
That's
So, how do you know him? Okay. And, I mean, have you been with him all day?
I've been with him all day.
Okay. So when did he park his car here?
He parked here at 10:30.
Okay, were you with him when he parked it?
Yeah.
I'm sorry?
Yes. I was
Okay.
with him.
Was
I
it
picked him
damaged
up.
when he parked it?
No, no damage.
No damage at all?
No damage at all.
Okay, you got your ID on you? How long have you known him?
I've known him since I was like younger.
I'm sorry?
We met when we were little, like younger.
Okay, but how long have you known him recently?
What do you mean? I've known him
Have you
since I
known,
was like 14.
you've known him, see him weekly, monthly, all since you were little?
Pretty much.
Okay.
I mean, it's been,
What do you mean?
like, I mean, I don't see him every day, but like.
Okay.
Stop for a second. Pause.
I believe that was part of what the state agreed to move past.
Where it was about to go?
Yes.
Okay, and nothing that we had.
Correct.
Okay, so far so good. I don't know what's coming next. You do. So do you disagree with Ms. Wood or you were about to pause it?
Judge, I do disagree, but I mean, what's going to happen between now and when I do need to skip is negligible.
Okay.
I can just skip ahead.
Okay, great.
This is the problem I have. That car was involved in a hit and run. It hit somebody, broke their leg.
I
They
don't
went to-
believe it was that car.
Yes, it is.
I don't believe that.
I do, because we have parts of that car in evidence right now.
I feel not believe that because he's been with me all day.
Yeah, this happened Friday night.
I know nothing about that.
Okay, when did he park the car here?
This morning.
You saw him park the car?
Yes.
You didn't see damage there, did you? Okay, is that what you're going with?
Yes.
Okay, so I'll charge you with obstruction when I find out. Get
I
everything
didn't see any damage to any car.
You didn't see damage to his car?
Not until we pulled in the car.
Okay, that's fine. Have a seat. Actually, one starting at 85. Sean, go get your flashlight.
Anybody else have a key to it? You left it?
I hope they, you know what I'm saying? I hope they, like I told, I was letting my homeboy grab the scope. I hope they know how to go with that. You know what I'm saying? But I don't know.
Secretary 185 cleared, budget to be expended, come from lot.
Mercy.
Yeah. As soon as I come, approximately 9. Yes, sir. Yes, sir. Oh, yes, sir. It was like a church. It was like a church. Church. Everything was intact. So everything was intact. No showing. Yeah, you know my car. I just got used by the money though. So y'all know my other car. I've been pulled over by y'all too many times. So
Judge,
Yes.
overheard some of the conversation that I know. Hold on. I think that's it, Judge. Officer Lewis, Officer Lewis, do you recognize? Judge, I'm approaching states 8 through 12.
Okay. You've seen these, Ms. Wood or Ms. Feely?
Yes, Judge.
Okay.
Officer Lewis, do you recognize these items that I've just seen?
Yeah, these are copies of the photographs I took.
And do they appear to be fair and accurate photos that you took?
Yes.
That night? And do they appear to be altered in any type of way?
No.
Judge, since they would request to admit states 8 through 12.
Any objection to states 8 through 12?
No, Your Honor.
They're admitted.
And you states 8. Can you describe?
Is there a way we can get these up on the screen?
Yes, Judge.
You need to, there we go.
Is that the photo that is in front of you?
Yes.
Okay,
there we go.
Can you describe what this is a photo of?
This is the parking spaces directly to, next to the Highlander. What I was trying to show is that there were no vehicles parked there, no tire marks. You see the layer of dirt there. Basically, it's dirt or mud that's left, standing water. When the water drains away, it leaves a layer of dirt. It shows both parking spaces, just the dirt with no tire marks, no footprints, nothing like that to indicate a vehicle or anything was parked next to the Highlander.
And the Highlander would be where it looks like we see to the left, the rear of that black bus.
Now that's the bus on the left.
Yeah.
And 2 spaces over. I believe this picture may have been taken after the Highlander was removed.
Okay. We would have seen the right rear of the Highlander if it was still in the spot at the far right corner.
Highlander, I believe, was parked where the arrow is.
Okay.
So this must have been taken after the Highlander was towed.
Okay.
Yeah, because I recall there's a space and a half between the Highlander and the bus. So where the arrow is right now is where the Highlander was parked.
Okay.
And I'm going to pass you states 11 as well.
So he can have it on the screen so you don't have to keep coming back, or you can leave all the pictures with him and he can look at the paper versions.
Got it. So if you conclude that no car was parked there, how does that impact, the ultimate position of whether the car was damaged at that location?
Just the lack of evidence of a vehicle being parked there, and the lack of debris from the Highlander being on the ground. As I testified earlier, and you can see this picture here, the headlight assembly and the turn signal assembly is shattered, missing glass. There's a portion of the bumper there that was ripped off. And like I said before, the exterior mirror is gone. There were absolutely no debris on the ground at all. And if there was, someone swept it up, there'd be brush marks from a broom or whatever they used to pick it up. And the way that headlight was shattered, there would be hundreds of pieces of glass on the ground.
Do you have, Officer Lewis, do you have any background or expertise in accident reconstruction at all?
Yes, I'm actually currently assigned to the traffic investigation unit. I've had extensive training. I've received training in what's called on-scene accident investigation level 1 and level 2. That's a total of 120 hours there. I've been to accident reconstructionist level 1, level 2, and level 3. Those are each 36 hours of training.
How many levels are there?
There's actually 5, and then there's in-depth classes after that, more experienced classes.
And in addition to taking classes, how many, say, incidents like this do you get to employ your skills?
Hundreds, if not thousands. I've been a cop for a while and investigate accidents almost every day.
Okay. Did you observe, because you actually had an opportunity to look closer at the vehicle, did you observe any paint from any other vehicle on this car?
No.
Okay. Did you observe any debris of any other type of car around this car?
No.
Did you observe anything to lead you to believe that a vehicle struck this vehicle or anything struck this vehicle in this parking lot?
No.
Nothing further, Judge.
Ms. Feely?
Again, briefly. So the bolo that you looked at, when you took your shift that day.
Yes.
That's how you knew that this was a Toyota Highlander,
I
right?
was involved in a hit and run, yes.
And because somebody saw a Toyota Highlander hit the pedestrian.
I don't know that.
You were not told it was just a tan car though, right?
No, it was specific, the Bolo specifically said a 2001 to 2006 Toyota Highlander.
Thank you.
Mr. Hand, any follow-up?
Yes, Judge. What county with this?
Fulton County.
Okay, thank you. No further, nothing further.
Okay. Questions for Officer Lewis? Yes? Okay, jot them down, pass them to Deputy Gordon, please. One side of the card only. Thank you. Just a little. Officer Lewis, where did you work before working at Roswell Police Department?
Served 9 years with Dunwoody Police Department and 11 years with Cobb County Police Department.
So this isn't your first rodeo?
No, sir.
All right. The accident reconstruction training, whatever you've described it as, in your level 3?
Yes, sir.
Did that start only after you joined Roswell Police, or is that something you began to accumulate in Dunwoody or Gwinnett?
I originally took on scene 1 and 2 19 years ago when I first started my career. And that's the basics of accident investigation. The recon classes started this past year after I joined the traffic investigation unit.
Do you know if cell phone records were obtained for Mr. Christopher in connection with this investigation?
I read a supplemental report that they were obtained.
You didn't obtain them?
I did not.
And you haven't had a chance to analyze them? Okay. All right. Any follow-up, Mr. Hand?
No, Judge.
Ms. Feely?
There you go.
Officer Lewis, thank you for being here.
Thanks, sir.
Ladies and gentlemen, we're going to take our afternoon break and try to get you back in here at about 3:40. Unless you need more time. You always have the ability to tell Deputy Gordon politely, not yet, but I'd like us to get in as much evidence as we can. We didn't talk officially about quitting time. It's 5-ish. There's not a bell that goes off other than the fire alarm at 5 and everyone runs out. As we approach 5, I'll ask whoever is examining a witness how much more time they have. And if they say, hey, I could be done in 20 minutes, and we all think it's a pretty reliable estimate, we go to 5:10 so that we finish at a natural break and a witness doesn't need to come back tomorrow morning for 3 minutes of questioning. But my commitment to you all was 9-ish to 5-ish. So if one of you has to get out of here at 5 for kids or dogs or whatever, let Deputy Gordon know and he can let me know, look, one of the jurors can't stay to 5:10. I'm not talking 5:45, but we may spill a little past 5 if that gets us to a natural break point. Okay. We'll get you back in here in about 10 minutes. Don't talk about the case, no outside research. Mr. Hand, anything we need to talk about before we break?
Judge, the state,
Rests?
no. Will not be calling Sergeant Fortunato.
Okay, virtually or otherwise?
Exactly, Judge.
Okay.
We will proceed with, Detective Kowalski.
That's who's next?
Yeah.
Okay. And the fact that you're skipping Sergeant Fortunato doesn't mean you're going to run out of witnesses today before we're done. How are we doing with your estimate that state might rest by lunchish or early afternoon tomorrow?
I think that's accurate, Judge.
Okay, great. Super. Anything from the defense?
No.
Is there anything about Detective Kowalski that we need to discuss in advance because his body cam video or something has areas of concern?
I don't believe so, Judge.
Okay, great. I don't have anything else on my list to cover either. Enjoy your break. You sure can. Unless it relates to the Cook case. It is the Cook case.
And then, oh, I see this.
No, Cook case. Okay. Yeah. I did, and the video came up. It was from like here down, all garbled, and there was no audio. So I could see him moving around, and some detective handed him something. There was no audio. So then we tried that one that looks like a traffic cone. And it was the same issue. And so then they even went online and found something called Tiny Wow and tried to convert it, and none of that worked.
Well, on that jump drive is it says release codec.
Mhm.
So I put the codec for Windows Media Player on the jump drive. So you
Okay.
can click open the folder, go to the setup, and just follow the prompt.
And it might work that way.
It should.
Okay.
And if it doesn't, I'll just bring my laptop over.
We'll figure it out. How long is the interview?
Like half an hour. It's like
Okay.
45 minutes at most.
Is it we read you your rights and you execute a waiver? He's in custody, but he may have been in custody for something else, so it's not custodial in that respect. Okay.
She reads me the rights.
Okay. I remember Gladys saying, I may not even fight this, but I want to talk to my client. And then he turned into a pumpkin. Johnson hadn't done anything and talking to me about this. So we'll just need to figure out his perspective, but you'd still need a Jackson Deno one. Okay.
And this will probably be tracked as something different because I'm specialist set in Richardson on the Parks and Lawn.
Okay. Huh, that's going.
So I know.
No.
Well, we'll see.
All right.
Thank you.
You bet. Thank you.
Oh, no. I wasn't surprised. I told him I'm letting I use that on everything. I check it out. I still do it on the. Are you eating more?
Hurricanes are right left, so we're gonna hurry.
You're moving, yeah. Oh, yeah. It needs to be on a jump drive, so we don't have to delay all that.
I have a great one. Yeah, it's probably, yeah.
Yeah.
Any after?
I emailed him again, I haven't heard back.
Okay.
When I do, I'll let you know. What you got going on?
Nothing, he needed a jump drive for, Tolbert. I guess his isn't working, whatever's on the USB.
Do you have any Tolbert?
Mhm.
Oh.
I guess we had done it, Mario Gladys, we had done a motion for the statement. And so, he had emailed me this morning saying, I filed a motion on the case there. And, I gave him a hard copy. Yeah.
Ice cream?
Yeah. That's what I was trying. Because I think.
Mr. Malkin, is Mr. Hand able to come back shortly?
Yes. I will cause that to happen.
Like magic. All right, Ms. Rivers, you ready? Let's go back on the record in State versus Christopher. We've got our prosecutors here. Mr. Christopher and his lawyers are here. Anything, Mr. Hand, before the jury comes back in?
No, Judge, nothing.
Anything, Ms. Wood, before the jury comes back in?
No, Your Honor.
Let's bring the jurors in. Thanks.
Yes. Yeah. You want first? Yeah, he has to go first. He'll be here.
Should say thank you.
Thank you.
Yeah, of course.
All right, adjourned.
Thank you, Deputy Gordon.
stay past.
Pardon me?
Can't stay past 5.
Okay, so 5-ish is less good than 5. All right, we'll work on that. Your next witness, sir.
Yes, Judge. The state calls Detective Kowalski. That Kowalski.
I just will affirm that testimony will be the truth, the whole truth, nothing but the truth. So I just go ahead and have a seat. Say your name for the record.
Zachary Foxen Kowalski, Zackery, Foxen Kowalske.
Good afternoon, Mr. Kowalski.
Good afternoon.
How are you doing?
I'm well. How are you?
I'm good. Mr. Kowalski, can you state to the jury what you do where you're employed, or the opposite, where you're employed and what you do there?
Sure. So I'm a detective with the Crime Scene Investigations Unit for the Roswell Police Department.
And what do you do in that role?
Within the Crime Scene Investigations Unit, we handle kind of two functions. The first is a field service response where we go out and investigate crime scenes. So go out, collect evidence, document the scene, fingerprints, DNA, all that kind of stuff. The other aspect is we also provide certain laboratory functions within our offices. So depending on the forensic discipline, we may do it in-house.
Okay. And how long have you been in that role?
In that role, so I've been with Roswell since January of 2009, and I've served in a variety of different divisions and units, but the majority of my time has been with the crime scene unit.
Okay, so about, say, 13 years total?
So 14 years with Roswell, just about, and probably 9 of those, if I had to take a swing at it, with CSI.
Okay. And what were you also employed with Roswell December of 2020?
I was.
And do you remember being asked to perform any type of analysis as related to a hit and run for Roswell PD?
Yes, so our unit was requested to process a vehicle for latent evidence as well as any type of DNA or physical evidence collection based off of the particular traffic case.
Okay, was there a particular type of analysis you were requested to do?
Several. So latent print analysis, fingerprint development and collection, fracture analysis, evidentiary collection, DNA sampling, to name the majority of the services.
Okay, and let's talk about your background.
Sure.
Before we get into that, let's talk about your education background. What are your degrees?
Sure. So I have a Bachelor of Science in Investigative Forensics with a minor in Terrorism and Critical Infrastructure. I have a Master of Science in Forensic Science, and then I'm a PhD researcher in Forensic Science, where my dissertation research is in forensic science, bloodstain pattern analysis mainly. Yes, ma'am. Where'd I lose you?
Particular analysis is.
Where my dissertation research is in bloodstain pattern analysis.
Okay. And I want to focus specifically on the fracture match analysis that you perform. If that's the correct name for it.
Sure. So physical fit examination, fracture analysis, it has a few different terminologies that are synonymous.
Okay. What is a fracture analysis or physical fit analysis?
Physical fit examination or a fracture analysis or fracture matching, that is where we've all kind of put together jigsaw puzzles and you have different puzzle pieces and you're looking for associations between two puzzle pieces, right? So that is the joining or the association of two items if they were once joined together. So if I tear a piece of paper, I have a shear force. I have some kind of energy that has been displaced and it has caused some kind of tear. This tear exhibits certain characteristics both on the macroscopic and microscopic level that are unique because no force is going to be the same. The construction of the material isn't going to be the same. So it is the merriment of associating those back together to where they were once joined, if that makes sense.
It does, it does. And where did you learn to do this type of analysis?
So fracture analysis was studied as part of my graduate level work, as well as workshops outside of the college level through several conferences, International Association for Identification being the predominant one, as well as textbooks and online materials as well. I have, as part of my forensic training, probably about 1,200 hours of forensic specific training in a variety of different forensic disciplines, to name a few.
And you're at Roswell PD. Do you also go through like the normal police training as well?
Yes, so I'm a post-certified police officer since 2010. I have the basic mandate 408 or 412 hours, but in addition to that, I have probably about another 12 to 1,500 hours of investigative and law enforcement general training. That includes everything from large, complex homicide investigations to accident investigations, to kidnapping, lots of different law enforcement disciplines.
So thinking specifically about fracture match analysis or physical fit examination, how much experience have you had actually applying that technique?
Sure. So within criminal casework, probably 3 to 5 specific service requests that are where it's in some case where we're asking, to associate one item with another item through the lab. As part of my law enforcement career, and I was also assigned to traffic for a period of time, I've investigated somewhere between 700 to 900 traffic collisions. And as part of that, it's often you see vehicle debris out on a crashing, and you're associating from a macro level where certain automotive pieces belong. It's something we all kind of do is, associating based off of macro and micro characteristics if two items were once joined together. So hopefully that answers your question.
It does. In those 700 or so cases that you spoke about, 700, 900, what type of analysis or what type of material were you looking at to do the exam?
Within those cases, you're typically looking at automotive metal, so or automotive plastic, depending on the make and model of the vehicle. So you're looking at different types of plastics or different types of polymers or different types of sheet metals. It just depends on the specific type of vehicle.
Judge, based on that information, the state would request to tender Detective Kowalski as an expert in, want to get this right, physical fit examination and fracture match analysis.
Are those two categories that make sense to you, Detective Kowalski?
Yes, sir.
Okay, physical fit analysis and
Fracture match
analysis. All right, Ms. Wood or Ms. Feely, do either of you want to examine Detective Kowalski at this point in terms of his qualifications?
No, Your Honor.
Okay, any objection to having Detective Kowalski designated as an expert for the purposes of this trial in the two fields of physical fit analysis and fracture match analysis?
We weren't given notice of an expert, and I haven't seen any resume or anything like that. So
Okay.
we would object.
Did you provide notice to the defense that Detective Kowalski would be providing expert testimony?
I did not, Judge. We did provide the defense a copy of his expert report or examination report, which includes an expert opinion. And so.
Okay, so this is more like a coroner coming in who needs to be designated as an expert before she says this was the cause of death, not relevant to this case.
Yeah.
And so the expert opinion, if you will, is contained in the medical examiner's report. And you're saying you provided to the defense Detective Kowalski's report about fracture match analysis or physical fit analysis.
Yes,
okay. Is that a report that is ringing a bell for you, Ms. Wood or Ms. Feely?
If we could just confirm that the documents that I'm looking at are what. Mr.
Okay.
Jenkins-
If you've had what he's referring to, then I think we will proceed. If it's something different, then we won't.
Because I was looking at that. No objection, Judge.
Okay, so Detective Kowalski, I am designating you as an expert in the fields of physical fit analysis and fracture match analysis for purposes of these proceedings.
Can you identify what came you?
What's been identified as State's Exhibit number 13 is my laboratory examination report for a comparison of a broken section of automotive plastic recovered from scene, as well as a broken tan Toyota Highlander front bumper.
Does this document appear to be accurate?
Yes, I recognize it.
Does it appear to be altered in any particular way?
No.
The state will move to tender State's Exhibit 13, which is the vehicle examination, laboratory examination report for Dr.
Okay, any objection to S13, Ms. Wood?
No objection, Judge.
It's admitted.
Detective Kowalski, can you describe what this report details?
Sure. So this is just the written version of my findings from, I was requested by the traffic investigations unit or the traffic enforcement unit to compare automotive plastic that had been recovered from the scene of a collision to that of a recovered vehicle that also had damage. So this is documenting that those findings both on a class characteristic level as well as an individual characteristic level.
Can you explain what that means by class?
Sure.
And individual?
So class characteristics are, if we think about broad categories, right? So we're all wearing shoes, right? Some of us are wearing Nikes, some of us are wearing Adidas, right? So that's a category that we can now put a specific item into. We can further go, well, are they blue or white? All the blue shoes are going to go over here, all the white shoes are going to go over here. And we can start narrowing down by characteristics more and more. Those characteristics are class characteristics because you and I can be wearing the exact same type of shoe, but they're different, right? Because we have walked on different types of surfaces and caused unique cuts and tears or wear patterns on the bottom of those shoes that make them individual to me. And those are individual characteristics. We can associate the same thing with fingerprints, right? So fingerprint patterns, we all have fingerprints. Fingerprint patterns are loops, swirls, and arches. And all of us may share some of those broad category classes. But as we start looking at the unique patterns within it, we start seeing different minutia or individual characteristics that make that fingerprint unique to you. Same thing when we are looking at two items such as automotive plastic or automotive metal. I can look at both things from a class character perspective and say, they're both of the same color. They're both of appear to be of the same type of plastic and thickness. Those are class characteristics that help me put it into a specific category. But then do they have the unique different tears when we start looking down at a more microscopic level in terms of striations in the plastic, the tear pattern or the shear pattern from where that plastic was broken apart, and we start marrying them back together, right? It's that reciprocal joining of two pieces together. So that's class characteristics and then individual characteristics as it kind of applies to this.
And you looked at both of those. Is there a reason why you looked at both instead of one over the other?
So the methodology is that you start with looking at both individually. It follows what's called the ACE-V methodology. It's the exact same methodology we use in fingerprint analysis. So that first part is that analysis, and it's where you're looking at each individual item and understanding what type of damage it may have. Once again, looking at those class characteristics or those unique details that it may contain. And then you're going to do that for the other item as well. And then you're going to go into comparison. And it's where you're starting to compare those different damages or tears or shear patterns. And then so after we have compared them, then we're going to go into the evaluation. And that's where I'm going to say, based off, make my determination on whether or not they are congruent together or derived from a common source to where they were once joined together. So within this particular case, where I have circled in the report are parts of that tear or that damage that help illustrate that, right? You have curves, you have sharp lines, sharp 90-degree turns from where that damage originated from. So it just helps show that kind of that macro level, if you will, of the joining back together.
Let's take one step back or two and look at this photo. You were provided what items in order to perform this fracture match?
Sure. So item number one is a broken section of tan automotive plastic recovered from the crime scene. And item number two is one broken tan Toyota Highlander front bumper.
And can you confirm what case this was related to?
Related to Roswell case number 2012000381.
Were you told what suspect was in that particular case, the name of the suspect?
I don't recall if at the time I was informed of any suspect information. I may have, but I don't recall.
Do you remember the type of vehicle you were comparing this plastic to?
Toyota Highlander.
And is there... So what is your conclusion based on employing your comparison techniques to determine what is your conclusion as it relates to whether this bumper piece you were supplied originates from this particular vehicle that you also had access to?
That it's support for the same source. So that meaning that they join back together. There is sufficient detail to say that there is a physical fit association there.
And can you give that with 100% certainty?
No, I will never give 100% certainty. I will just say that based off of, because there can always be probably some type of variable that I can't comprehend, but I don't assign a weight or a statistical interpretation. It's a pattern comparison. So just based off of the specific details outlined, that there is sufficient detail there to associate the two items together.
Would you say you're fairly certain?
I would say that I would say that there is sufficient detail there to have supportive evidence for a same source.
Have you ever had a fracture match analysis where you confirmed that you came to the conclusion that it was the same source, but then found out that was not correct?
Not that I'm aware of.
All right, no further questions, sir.
Ms. Feely, Ms. Wood, any questions for Detective Kowalski?
No questions, Judge. Thank you for being here.
Yes, ma'am.
All right, jurors, questions for Detective Kowalski? Oh, yes, yes. It's good to get Deputy Gordon up every once in a while. I appreciate you doing that. You could just write "Hi, Deputy" on the card. All right. Thank you. So were you involved in acquiring cell phone records in this case?
I was not.
Thank you. You are free to go.
Thank you, Your Honor. Thank you.
Sorry that we deviated from the normal course, but I felt empowered. Next witness.
Judge, the state calls Detective Romano. Romano. Yeah.
Lord, sit and raise your hand. Do you swear affirm that testimony you will give is the truth, the whole truth, and nothing but the truth? Yes. So now, see, state and spell your name for the record.
My name is Daniel Ramuno. Spell it Ramunno.
Dr. Ramuno, can you tell the jury where you're employed and what your role is there?
I'm employed through the city of Roswell. I do traffic enforcement, fatality investigations, and serious injury investigations.
Okay, and your official title is detective, correct? Or not?
It's still officer. We do investigate, but
Okay. In December of 2020, did you have that same title that you have now? Or
Yes.
did it kind of change? Okay.
yeah, I did.
And how long have you been with Roswell?
13 and a half years.
Okay. And has it always been the same capacity throughout those 13 years?
No, I was on patrol before that, but those are the only two.
And I know you explained what you do, but more detail, is there a particular class of investigations that you look into?
Yeah, I've taken the traffic classes. I've taken on-scene level 1 and 2 and reconstruction 1 and 2. I've also taken a CDR class pertaining to my job title.
And what are those classes particularly touching?
The CDR class touches on getting essentially the black box of the vehicle, which downloads a computer device, which you can get speeds, steering input, other information like that.
And do any of them touch on observing damage and being able to determine, make conclusions based on damage to cars?
It can show speed at impact. It won't activate unless it's a serious impact to the front end of the vehicle.
Oh, you mean the box?
The box, yeah. It won't start recording unless there's a serious type of impact.
But you cannot look at an impact and say how fast a car is moving based on that, or can you?
I don't have that training. Some other officers do.
Okay. And
mine is based on skids.
As in like skid marks?
Like, yeah.
Okay.
The car skids and crashes.
So you would need like skid marks in order to make it.
Yeah, that's correct.
Okay. You investigated this a case in December 2020 regarding a hit and run?
Yes.
Correct? Okay. Do you remember that case involving individual found on the side of the road in Roswell?
Yes.
Do you remember the location?
It was on Dogwood Road, just south of Grimes Bridge Road.
Okay. Did you go to the scene that day when the hit and run occurred?
Yes, I was called out from my home, responded. By the time I got there, it was just vehicle debris. There was no victim or vehicle there, just other officers who had closed the scene down.
What happened to the victim?
He was transported to the hospital.
Okay. And you said there was no debris?
No. I said that's all there was when I got there.
And what did you observe from the debris when you arrived?
There were several pieces of car parts on the right side of the roadway if you're traveling northbound. I believe prior to my arrival, other officers determined what type of vehicle it was and a base kind of year we were looking for that hit and run vehicle.
Is there a typical way, if you, for instance, is there a typical way to determine a make and model?
Yeah, with certain serial numbers, if they're available on that stuff, which I'm assuming another officer did prior to us getting there.
Okay. And so let's say what car here are you particularly looking for or on the lookout for based off this incident?
The Toyota Highlander.
Okay. And do you have a color that comes along with it? Or just...
Yeah, it was a gold color. I'm trying to think of I don't remember the year. I've got a supplement with shows the years we were looking for.
Okay. And let's go back to the scene. Did you create like a report based on the incident that occurred that night on Dogwood Road?
I created the initial incident report was created at that point. The accident report was not.
Can you explain the difference between the incident and the accident?
An incident report is more of a narrative. We would do an incident report on an accident if that's serious or there's more to it. If it was just a normal accident, not serious injuries, we would just do the accident report. It has the diagram and the vehicles and their insurance on it.
Okay, and let's stick with the accident report where there may or may not be diagrams. In order to figure out what happened, what type of information do you investigate and acquire to figure out what happened in alleged hit and run?
In this case or in general?
In this case.
Yeah, in this case, obviously we had a victim who was struck by a vehicle. We have car parts, the part of the roadway where the car parts were on. I believe it was the victim's accounts where he was struck in the back. So we've got direction of travel. And then obviously we have that vehicle placing the parts with it, the hit and run vehicle. We matched all the parts up.
Okay, and did you ever confirm the owner of the vehicle that you ended up matching the car?
Yeah, it was through, he had reported that his car was struck in a parking lot. He was the owner of the vehicle.
Okay. And do you know did you ever speak with him?
No.
Okay.
I was not there at that time.
So the next day when there was a car reported damage, are you aware of an incident that happened December 13th where a car was reported damaged?
Yeah, and I read that report and obviously determined that was the vehicle that was involved in the hit and run.
Okay, but that was based on after reviewing what?
The accident report.
Okay.
I mean, his incident report for the false report of a crime.
Okay,
The initial one.
so we've got your incident report, got the statements by the victim, and did you review any other type of analysis?
His narrative in that report, obviously has the only keys to the car. That's the vehicle that we were looking for. He couldn't determine any other drivers. At this point, we know that this car is involved in the hit and run on Dogwood Road. Obviously, this crime's trying to be concealed.
Is there a crash report that you created associated with this incident?
Yes, that was created after the arrest warrants were taken.
Okay. To say showing opposing counsel.
Oh, thank you.
This is states 14?
Yes, sir.
Okay, and it is?
This is the crash report. Motor vehicle.
Accident report?
Yes, it's
Slash accident.
Yeah.
Can you, do you know what this document is?
Yeah.
Okay.
Yes, I do.
And do you recognize it as an accurate depiction of what you know it to be?
Yes.
Does it appear to be altered in any way as well?
No, not that I can tell.
Can you describe so there's a diagram in this report, correct?
Correct.
So you should take that down. It hasn't been admitted yet, so there's nothing to publish.
There's a statement request to admit states 14.
Okay, any objection to the admission of states 14? Pardon me?
No, Your Honor.
Okay, any objection to publishing any parts of it?
No.
Okay.
That, thank you.
Okay, it's admitted and you may publish.
Detective, what is this that we're looking at?
This is the picture of the accident diagram.
Okay. And what is it depicting?
A pedestrian on the side of the roadway and a vehicle traveling north striking that pedestrian.
Okay. And based on your investigation, where is the victim actually struck?
In the backside.
Okay. Physically in relation to the road, did you make a determination?
Where they were standing.
Yes.
At
the moment of
I wasn't able to determine at the moment of impact where he was standing.
Okay. But you were able to determine it was hit from behind.
Yeah, he was on the side of the road and the vehicle damage was on the right side of the vehicle.
Okay. And did you observe any skid marks at all on the ground at the hit and run location?
Yeah, no, I don't believe so.
As a result, were you able to determine how fast the car was traveling?
I need you to answer out loud just so the court reporter can take it down.
Okay. No, I was not.
So you have an incident, you have created a report of what occurred. How do you come to the conclusion who the suspect is?
Obviously, we have the vehicle parts and the vehicle that ties him to it. We have him trying to conceal the hit and run by reporting that it was hit in the parking lot on Pleasant Hill Street, I believe. He was the only one with the keys. He's the registered owner of the vehicle. He wasn't able to say anybody else was driving the vehicle. Most people would know who was driving their vehicle. So.
And based on that, were you able to secure arrest warrants for the defendant?
Yes, I had an arrest warrant for false report of a crime and one for hit and run.
What is, and you don't just create a arrest warrant, right?
No.
How do you get an arrest warrant?
We log into the e-warrant system. We apply for the arrest warrant. We speak to a judge and then the warrant is signed and we print out the warrant.
Okay. And that's based on the facts that you allege?
Yes.
Okay. I am showing witness states 15.
Thank you.
Without saying what these are, do you recognize these documents?
Yes.
Okay. And do they appear to be accurate depictions of what they purport?
They should be. Yes.
Does anything appear to be deleted or altered in any way?
I would have to read through them.
Okay.
It appears correct.
Okay. And what are these documents?
There's
Name them based off the exhibit number.
yes. Exhibit 15 is an arrest warrant for hit and run. Exhibit 16 is an arrest warrant for false report of a crime.
Okay. And who are they taking out against?
Landon Christopher.
And is that the defendant
Correct.
report?
Correct.
Do you? When were those warrants granted?
Let's see December 28th of 2020.
Okay. And so those were granted in December. Do you know when Mr. Landon was arrested on those warrants?
I do not recall.
Do you need me to refresh your memory?
Sure. Yes, please. Okay, I see on my police report that it's February 4th of 2021.
And do you know if that's the exact date or just about that date?
It should be that date. I believe it is.
And he's arrested on those warrants.
Well, never mind. He was not arrested. I'm sorry. I was reading this wrong. This is where they retrieved the vehicle. I believe he was arrested prior to that.
Shortly prior to that, immediately prior to that?
I'd have to look at my. I don't have the date in here when he was arrested.
Okay.
Unless I'm missing something.
But you do know at some point he was?
Yes. Yeah, he was.
And let's fast forward to any information that may have come available after his arrest. Do you know if there was any?
Yeah, so I applied for a search warrant for cell phone data for his cell phone to get the location. It takes a while to get that information back. Once I retrieved that information, I asked our intel analysts to decipher the information for me. This is my first cell phone data search warrant, and she advised me that the cell phone was not in the area at the time of the incident.
In the cell phone, which cell phone are you talking about?
Landon Christopher's listed cell phone.
Did you analyze the cell phone data yourself?
No, I did not.
Come to a conclusion on your own based off reviewing other cell phone data that you thought was actually more accurate than?
I've never reviewed other cell phone data like that.
Okay. And so your supplement to this report that the cell phone's not in the area, that's something that you were told you didn't.
Yes, I was told that information. I wrote it in the supplement and then notified my supervisor.
Okay. But you personally don't know that information yourself?
No.
Could you have misinterpreted the information given to you and added to the supplement?
I'm not sure. No.
But you just added what
It's
you were told.
the email that she sent me stated that it was not, the cell phone was not in the area at the time of the event. So that's what I put in my supplement.
Were you ever given the raw data itself?
T-Mobile gave me that. I believe it was T-Mobile that gave me that data, and then I forwarded it to her.
And how do you know the data that was given was for the cell phone belonging to the defendant?
How do I know that's his cell phone? Again, it's been 2 years. I believe another officer helped me find that information. I don't remember what resources we use for that to be his listed cell phone, but.
So you receive records for the number, but not directly out of the phone?
Yeah, correct.
Okay. The data you received from T-Mobile, was it given directly to you from T-Mobile, or was it given to the analyst directly?
It was given to me from T-Mobile. It was sent in an email, and then I forwarded that to the Intel analyst.
Okay.
It came from T-Mobile. The information you received back from T-Mobile, did you review it at all? I looked through some of it, but I don't recall in this date, 2 years later, exactly what I read.
Okay. Would you be able to recognize it if you saw it?
Possibly.
Okay. Okay. Do you know who did the analysis?
Kelly Hooper.
Okay. And is she still with Roswell?
She is not.
So the warrants that were obtained before the cell phone data?
The arrest warrants?
Yes.
Yes, I believe so.
Okay. So before that information was given to you, you, based on information, the universe of information that you had as an investigator in this case, you felt certain enough to apply for an arrest warrant
Yes.
on this one.
Yes.
That there are complete thorough investigation.
Yes.
No further questions, sir.
Ms. Feely?
Good afternoon.
Good afternoon.
As a police officer, you're trained to write reports.
Correct.
And you've probably written hundreds at this point.
Correct.
And you try to do it as close in time to the incident as you can.
As I can, yes.
Because 2 years later, you might be called to testify about an incident.
Yes.
So you include as much detail as you have at that time, right?
Correct.
And then you supplement it as you get more information.
Yes.
And you reviewed your report in preparation for court today?
Yes, I did.
Thank you. And you
took the search warrant for Mr. Christopher's T-Mobile records pretty close in time to the incident, right?
I believe so.
But as you testified, it takes a while to get those records back.
To get the data back.
So around June 1st of 2021 is when the actual records got to you.
Yes,
Sound right?
I believe so.
And happy to refresh your recollection, but if that sounds right.
I believe it sounds right.
So at that time, that's when we found out that the records showed that Mr. Christopher's phone was not at the location at the time.
I'm not sure if that's the same time when the Intel analyst reviewed it. I'm not sure exactly. I guess it was when I did the supplement report, if that's what that says.
Would it refresh your recollection? Take a look at the
Yes.
report?
Because I got the data to send her the stuff. So. And you said when for the
June 1st of 2021?
oh, okay. Okay, yeah, this is when she completed reviewing it, correct? Thank you. Sorry.
So the conclusion was that Landon Christopher's cell phone was not in the area at the time of the hit and run.
Correct.
Thank you. You actually did a little more investigation and uncovered another witness. Do you remember Deep Patel?
So if you don't remember off the top of your head, that's fine. As you said, it's 2 years, but Ms. Feely is free to show you a document that might refresh your recollection.
Yes, that would be nice. Oh, thank you. Okay.
So you observed what you call vehicle fluid trail in the roadway.
Near where the pedestrian was hit?
Right.
I believe so.
And then you followed that into the Dogwood Road area.
I don't know if it was me or other officers, but we had several people canvassing the area.
And you uncovered a witness named Deep Patel in that subdivision.
I thought that was Officer Carr.
So you don't know anything about Deep Patel?
Not
that,
you know.
That's a valid answer.
I
Thank
believe
you.
it's Sergeant Carr.
Thank you.
Yeah.
Any follow-up, Mr. Hand?
No, Judge.
Okay. Any questions for Officer Ramuno from the jurors? We have some, Deputy. Come get him. Thank you. Officer Ramuno, skid marks. Would there only be skid marks in the area where the hit and run occurred if a vehicle braked or lost control, or would there be other reasons that there'd be skid marks?
There could be skid marks from the vehicle doing yaw marks going sideways. There's different instances.
Okay. Did you receive any other conclusions from Ms. Hooper about the cell phone records beyond the one you memorialized in your report?
No, I did not.
Okay. Mr. Hand, do you have any other questions for Officer Ramuno?
Yes, there's one question. Well, we'll see what the answer goes, but for now. Detective Muno, did you take Analyst Hooper's statement that the cell phone was not in the area to mean that it didn't ping off a tower, that it was dead? How did you interpret that statement?
I interpreted it as the cell phone wasn't GPS in that area. Like I said, I'm not familiar with the cell phone data thing.
Nothing further.
Ms. Feely?
Further, thank you.
All right. Thank you, officer, for being here. Appreciate it. You should take whatever's yours and anything else you can leave there and the lawyers will deal with it.
Thank you.
You bet. Next witness.
Judge, the statement request, can we continue tomorrow? I mean, we can call the next witness, but.
Let's call the next witness. If we don't get through the witness, that's okay. We're going to stop. The word is we need to stop pretty hard at 5. And so what I'll probably do is wrap us up leading into 5. But we got 20 minutes that I'd like to use, unless you can tell the jury by looking at them that you plan on resting by lunchtime tomorrow. If that's not in the cards, let's use this time.
I do plan on resting by lunchtime tomorrow, but.
Okay. You think even if we start at 9-ish tomorrow, you will be through the rest of your witnesses? I know you don't control cross-examination, but you envision, based on the way crosses have been going, that you'd be resting by lunch tomorrow.
That is, yes.
Okay. All right.
That is my vision.
You all heard what Mr. Hand said. And we will see you all as close to 9 as you can make it. You've now got a little sense of what it's like to get down here. I think the weather should be a little better. It's been totally foggy all day, but I think the rain is supposed to have stopped. So leave a little earlier if it was tough getting here by 9. I got the email of how many juries are being selected tomorrow. It's only 2 instead of the 8 that were selected today. So it should be easier to get in the building. Report to the jury room. It's open and ready for business by 8 in the morning or so. So you can get here that early. Know that the shuttles run only every 15 minutes at that time of day. So if you hit that parking lot at 8:55 thinking, I'm gonna make it because I'm only 5 minutes away, you may not get picked up by a shuttle until 9:10. And then you're running late and the other folks are waiting on you. Any logistical questions from anyone? All right, tonight, please don't talk about this case with anyone. Don't talk about jury duty. Enjoy other things in life. No outside research. You know how to get questions answered. And we'll see you all as close to 9 as we can make it. Thank you so much for your time.
All right, jury.
Okay, one of you left. Can you need to not leave your notepads in court. You should leave them in the jury room, please. So if you don't mind, one of you could just grab those 2 notepads. Thank you. And just, or however many there are, and bring them to the jury room. Thank you. There's a hidden one. There you go. Thank you. Pardon me? Let's put them in the jury room. Thank you. All right, you all can be seated. What witnesses do you have left besides Kayla Newborn?
Judge, the state has a rebuttal witness, which would include Katie Newborn, Kayla Newborn, and
So I'm confused. You don't have to rebut anything yet because it's your case in chief. So
you're saying just for the, okay, sorry.
between now and lunchtime tomorrow, you are calling 2 witnesses.
Yes. We intend to recall Officer Bath. There's one piece of testimony that we left out.
Okay, and Kayla Newborn?
Yes.
That's it?
That's it.
Okay, and then you're resting.
Then we will request it from the medical records, Judge, without testimony.
Okay. But your 2 witnesses will be Bath, which I assume is pretty brief, as long as you need, and then Ms. Newborn.
Yes.
Not Ms. Hooper. Okay. And then you say a rebuttal witness. If the defense doesn't put on any evidence, you don't get a rebuttal witness. Okay. Ms. Wood, at this point, and you're not bound by what you represented, that's your forecast for tomorrow. It may be that you bring someone in, you can talk about the cell phone records, whatever you're able to do. But assuming the state calls Officer Bath back and Ms. Newborn, and that's it, what do you forecast for your presentation?
Judge,
Your client or no one, or you maybe have some witnesses?
I would say 1 witness, but we'll have a better forecast after the 2 state witnesses in the morning.
Okay. The only witness listed is Ms. Hooper. So is there another witness that I ought to know about and the state ought to know about?
No, Your Honor, I was just factoring in whether Mr. Christopher is.
Sure. Okay. Mr. Christopher, at some point tomorrow, probably around lunchtime or so, you and I, with your lawyers present, the jury not present, but on the record, have to have a conversation about whether you want to testify. And I'll be asking you whether you want to testify, telling you the consequences of testifying and the protections you enjoy if you don't testify, et cetera. But when we're done with our conversation, I won't turn to Ms. Wood or Ms. Feely to say, hey, does Mr. Christopher want to testify? I'll be asking you. And your answer needs to be either, yes, I am, or no, I'm not. And not, I need more time to think about it, which is why I'm flagging it now. So I'm sure you have been thinking about it. I am confident your lawyers have discussed it with you. But when you and I have that conversation, it'll be time for you to say, this is my plan. And we'll make a good record of that and we'll handle it that way. Okay. All right. I am almost done with the proposed jury charge. I'll get that to you all tonight. So we'll have our charge conference sometime tomorrow. Now would be a great time to do it, but it really helps if you've read it first. And I'm not quite done. So I'll get that out to you all. And we'll figure out what happens tomorrow. It may be that the way it plays out is that we do our charge conference tomorrow, but we'll need to see what time it is. Whether you do your closings tomorrow and then maybe I charge the jurors Thursday morning. I guess we'll just need to see what time it is, see what we can fit in. All right. Do we need to talk about the newborn texts now? Because Ms. Newborn will be testifying by early tomorrow morning. You've got them now, Mr. Hand. What's your concern? Set aside the photos. I don't think we'd be sharing the photos with the jury.
I appreciate that assurance.
Yeah, I mean, there may be an argument made to share the photos, but we're not there yet.
Judge, the state just doesn't understand the relevance of the photos other than, if they're trying to use it for impeachment, but to just wholesale admit them, I'm not sure what the relevance would be.
Okay. I don't know who's handling Ms. Newborn, Ms. Feely. How would you envision using those texts?
If her testimony from 2 days ago was any indication, I anticipate they will swiftly become relevant. If she says she's afraid of him and all of that, that we anticipate she will say this is subsequent contact between the two of them that shows that they were still in contact and there does not appear to be an intimidating relationship.
If I may respond, Judge.
In a minute. So it's hard to put them in context. There are no dates. The way I tried to understand them, it's from your client's phone, and it would be texts that he exchanged. It says Kayla, and maybe Kayla will acknowledge that she's the Kayla. You should correct me if I'm getting any of this wrong. So your client is the blue bubbles, and Kayla, allegedly Ms. Newborn, is the black bubbles. Is that, first of all, am I correct as to who the two speakers are? Yes. Okay. I didn't know quite how to put them in order other than they appeared in a particular order, as they were attached in a particular order. So 7:06 p.m. on an unknown date. If we've got the people right, Kayla says, "What's up?" And your client says, "Sorry, wrong number," as in he didn't even mean to reach out to her. So she's not initiating anything. She doesn't say, "I'm scared of you" during the course of it. She clearly has been intimate with him, but I'm not sure. I understand some of this is contextual, meaning it depends how Ms. Newborn's testimony goes. So I don't know if what might need to happen is that you ask some questions about whether she exchanged texts with your client whenever this supposedly happened, but they're kind of unanchored.
Yes, Your Honor, and I actually don't know that I intend to enter them. I'm going to mark them, obviously, but I think it's just going to be to confront her if the testimony goes how we expect it.
Okay, so it's cross-examination, impeachment, et cetera. So I think we'll all be alert for that. I don't think I can make a ruling right now other than to offer the cautionary instruction of don't pop any of these on a screen until we've had a good discussion about it. What is your claim based on what your client tells you as to this March 10th? What year?
Yeah, it was this past,
This past March.
Okay. So 9 months ago. All right. That's helpful.
And he has indicated that he can resend those with the timestamp. And if we get those tonight, I'll send them to Mr. Hand.
Okay. I mean, there's a timestamp. It says Thursday, March 10th, 7:35 p.m. But that could be 2020, 2021, 2022. And it's of differing relevance. And I didn't hear Ms. Newborn say, I don't ever have contact with him. It sounds like it was a tumultuous relationship. The fact that she stayed in contact with him, I think you're able to explore that. And if she denies it, that may be a way to either catch her in conflict or refresh her recollection. I'd be reluctant to get too much into the content of the texts. All right. That clears my list. Mr. Hand, anything else from the state?
I don't believe so, Judge.
Okay. Ms. Wood?
There.
All right. Let's all be here by 8:50, 8:50 tomorrow. So we're ready for the jurors when they get here. Did they have an issue?
Mr. Johnson, he wants me to throw on.
Okay. He can come out.
He's out.
Hey, Mr. Shelton, come pick any seat in the jury box. So Deputy Gordon told me you wanted to chat, and I'm guessing it's what you alerted us to, which is that you lost a close friend to a hit and run very recently, and you had flagged that the funeral or memorial service, whatever, is tomorrow for your friend.
Yes, sir.
When is that?
It's at 12 o'clock, sir.
And where is it?
It's coming up.
I mean, you don't need me specific address, but is it in Atlanta or Macon? Okay. Any sense of how long it's going to be? Sometimes those can be 5 hours and sometimes you need to be present for some of it, but then you might be able to step away.
Yeah, I mean, mainly, if I would just be there for the service, I mean, I'll just have to let his parents know I gotta go because I have to get back to church.
Okay.
So this maybe an hour, hour and a half. I mean, because I don't think the service will probably last that long, or the service part.
Right.
Just all the extra stuff that.
The mingling afterwards, you'd be willing to step back from. Okay. So one way we could accommodate it is to just say, jurors, we're going to have a long lunch and everyone else goes to lunch. You're not going to lunch. You're going to that event. How long does it take to get there from here?
25 minutes from here.
Okay. And then you don't know exactly when you'll be done. You can let us know, but it could be that you need a couple hours to do it round trip. I don't know if you'd be able to interact with the family before things started so that you could let them know you're here and that you care, but you sit in the back and then you let them know, look, I'm gonna have to go because of jury duty at a certain point.
That's what I have to do is just.
I'd be more comfortable if we had a hard stop and say, I'm not going to let the other jurors know this is why we're doing it. You may have already told them and that's fine. But if we knew you would be leaving the services at a certain time, then if we ended at 11:30-ish tomorrow, you get out of here. But I know that at 1 o'clock, you're going to leave and be heading back this way, then we could let the jurors basically just have a 2-hour lunch. We can get them here a little earlier, but if we stop around 11:30, let folks know they need to be back around 1-ish. And then you'd get here as quickly as you could from the service.
Yes, sir.
Okay. Mr. Hand, do you have any objection to that?
I don't, Judge. I'm sorry, Judge. Can you repeat the times again?
So my thought is we'll do our charge conference at 11:30-ish. You may not be done yet, and that's fine, because we're ending a little before what I envision lunch being, meaning noon. Meaning we'll stop at around 11:30. We'll do our charge conference. We'll use that half hour in that way. But you'll be able to get out of here and go to the funeral. And then you're committing to us that it'll be wheels up for you a little before 1. You'll let the family know I'm here and I care. But I got this judge telling me I need to be back in court. And so for the other 13 jurors, it's going to be a longer lunch break, but we'll try to get back in session by 1:15-ish or so.
That works for me, Judge.
Okay. Ms. Wood?
That's fine, Judge.
All right. I think that's how we'll do it. I appreciate you bringing it up. We knew, because when we were picking the jury, I flagged for the lawyers. I said, remember, Mr. Shelton, he's got this situation that was the subject of much discussion. So I guess it's lucky for us that it's at noon because it makes it a lot easier to accommodate. Okay. So does that mean you'll be all dressed up tomorrow?
Yes, sir.
All right. So we'll plan on pausing around 11:30. You'll get out of here and you're telling us that you will leave the services wherever they are in the process a little before 1, so you can be back here as close to 1:15, 1:20 as possible. Does that works? Okay. Thank you. All right. Anything else, Deputy Gordon? Okay, then we're done. I'll see you all at 8:50. I think is tomorrow Wednesday? It is. Yeah, so be here by 8:50, please. Thank you.
Good evening.
You too. Are you Mr. Jackson? Great.